For pronouncement of judgment, item 47 to 49.
The writ appeals are held to be devoid of any merit and accordingly they stand dismissed.
Item 50.
We have interfered with the orders passed by the learned tribunal and the writ petition has been disposed of. However, we have also provided that the challenge to the dismissal order that will be considered by the tribunal on its own merits.
Apply. Item 51.
We have interfered with both the orders dated 37/24 and 1/10/24. The writ petition stands alone.
Deeply aware.
Adjournment request, if any, from item number 1 to 35. From item number 36 to 44.
In respect of item number 42, my lord, I beg to mention it will come after 2 weeks.
You earlier did twice or thrice.
My lord, actually, my lord, the issue involved in this case, the basic issue what is there, my lord, that is in connection with another Article 5 of 2024.
Learning single day has dealt with everything.
Yes, sir.
Certainly they
Another repeat.
can't ask for that thing of a promotional course or the basis of the qualification that was earlier there. That was law. After a week, not less, more than that. Next time you argue it.
May I approve the lordship? The consent of the other party, my lord. I beg to mention item number 40, my lord. I need the 40, my lord. Yeah, later maybe I'll come for maybe listed for after 3 weeks, my lord. Because I'm for the respondent, my lord. Lordship, a date can be fixed.
Yes.
Because my lord, recently passing away my father-in-law, my lord, I could not prepare a case, my lord. That is why, my lord, we requesting was.
Yes.
Lordship, I have a petitioner. Lordship, a date can you maybe fix?
In this matter.
Yes, Lordship.
Why? When you are dancing. Yeah, any date may be fixed after.
All right.
3rd December. Daily list for admission item 1.
It's not admitted.
It's not admitted. I've been told, yes, it has not been admitted.
It's admitted and
Very well, because the appellants are already working since 2013.
having heard the response for the parties, we begin to put it to admit this petition, hence admit. It should be noticed that despite paper publication of the notice, none has appeared on behalf of the private respondents.
My lord, and also departmentally, we serve notice, my lord. 257 of the respondent.
Department has also.
Departmentally, we serve, my lord.
It is informed by the council appearing for the state of Arunachal that the notices upon the respondents have also been served to the department where they are. Private respondents where they are working. Taking into consideration above fact, we deem it appropriate not to issue formal notice to the private respondents. This in due course.
This thing is,
Interim orders.
that is further orders. No further.
Interim order dated,
Interim order dated 28/4/20.
28/4/2021 is made absolute till final disposal of. The document.
Supplementary list, item 45 for orders.
Please, just one. Madam, I number 3468 is for impediment, madam. I provided the similar order, madam.
That order.
Madam, that starts from page 46. madam. The only difference was there were number of applicants. It's the single applicant. madam. It's for- Similarly situated, madam. Similarly placed. Yeah.
There are two applications for impleasement.
One is for impediment, madam. 3468 is for impediment and 3469 is for modification, madam. And modification also I provided a similar order, madam. Passed by. madam.
345. Mr. Manan, you have one implementing.
Yeah, the next item is mine.
345, sir.
So far, my learned senior friend that filed the ILO, we have not received the copy load.
Not madam.
Three, four, six, eight, and 3469, implement and everything.
3469 one more.
And where is that, another application vacating,
The modification, my lord,
modification.
that is 3469, my lord.
3469.
And the similar order is also provided, my lord, which was passed by my lord.
Yes, sir. 3460, 3468 and 3458.
The application number 34,
68
68 and 34,
and 57.
57. These applications, this order. Okay, page 45, 46 and 47. This, I'm marking it as one, huh? This one. And
Page number two.
this vacation order,
3458 and
there's only one modification and vacation.
two.
Yes, yes. Two applications each, my lords, one for improvement and one for modification.
In my case also both are for improvement.
34,
Only for implement.
no,
And modification as well.
Modification.
my lords.
3458 and 3469.
3458 and 3469. This second order.
Lordship, I have a small plan, Lordship. Lordship, मैं direct him to private book. But ask Lordship, otherwise Lordship. No, Lordship.
Okay,
No.
we are
Not me,
giving
not
you a
me, not me,
direction.
not me.
No.
We are giving you a direction.
No, Lordship, otherwise Lordship, it will be difficult to find the amended cost item.
That's what we are asking, we are giving you a oral direction, supply and copy
I'll supply today.
just now,
Yes.
just now.
Lordship.
That's
Deeply
all.
obliged, my lords.
Deeply obliged.
Item 46.
Kali order to proceed.
Hello, that order I have, my lord, obtained, passed by your lordship.
Yeah, yeah,
But there is one problem, your lordship.
yeah, what's the point?
That act was amended by CGST, your lordship.
Yeah.
State yet to amend their act. Unless and until they will not amend and insert subsection 5 in their act, my lord, the benefit cannot be given to me, your lordship. Because it is in respect of the notification and all passed by my lord central by way of legislation, my lord. If it is notification, I can understand, my lord. But since it is passed by my lord legislature, so they ought to have, my lord, either adopt it or amend in their state act.
What do you propose to do?
Lordship, here, the process of adopting or amending the act, Lordship, it's undergoing, Lordship.
By what time you are complete this process?
That, Lordship, I do not have that time period instruction.
Because subsection 4 of section 11 says, my lord, any notification in respect of, my lord, carry out the function of the act. But so far as, my lord, act insertion of new section in subsection, my lord,
You can do one thing.
my lord,
We'll add in in this order,
my lord.
the respondent authorities are directed to consider a pass and order 1655, dated 16/8/2000. No recovery pursuant to the impugned order shall be effected by the respondent.
That can.
The order include this,
My lord, page 35, my lord.
thirty-five.
My lord, 35, Annex 5. Order part under section 73, my lord.
Passed by the
Passed by my Assistant Commissioner of State Tax. Respondent number, my lord.
passed by the respondent number.
I have 3, your lordship.
This order, you have to introduce this order. There, this para number 8, you have to insert here. This para number 8. With these correction. Then petition is disposed of. Then petition is disposed of. Last minute.
Deeply obliged.
Daily list for hearing, item 2 and 3.
The state was to respond, could I have, if I pass over, my lord, the AG is on his legs. Could it be done after some-
The only difficulty is on 15th is the last date.
We are doing it today at 2 o'clock, my lord, if lordship.
2 o'clock is.
Item 4 to 35.
Item number 5. Item number 5.
It was in next step. Hello. All the advocates are present.
Lordship, our advocate general is not present today.
We should have circulated a slip for that purpose. It's not a- We should have informed them. That you are not going to argue the matter. So finally hearing matter.
Pertain to some.
At least you should have minimum courtesy of informing the court as well as the other side.
Lordship, my instruction is that let learned senior complete his argument and on next day, our advocate general.
In the next day, we'll hear today itself. The matter is regarding the validity of the provision of the entry tax, that's all.
Lordship.
We can't keep it pending. Maybe this bench may be available for what time or what, to what date. We are not aware of that. Any judgments on this other high court, on this point or not?
After the 9JJ bench judgment,
Yeah.
the 2 issues were left out. That was likely to be considered by the court. And that is the issue,
That is any other high court has.
I have not come across the. Other issues are now settled by the 9JJ bench judgment. Only 2 issues, that is about Article 14 of 304A. And whether, the putting of the levying of the entry tax in view of the Article 286 of the Constitution of India, that no sale or purchase the tax can be imposed, whether it is a culpable excise powers or the, the entry. That is the main two issues.
Only two issues. Then Mr. Advocate General is be able to argue the matter.
Mr. T. Advocate General of Assam, he is on in court number 17, Lordship.
No, here the.
We are, he will be
the
arguing.
provisions of the Assam Act as well as the Arunachal Act.
Yes.
Yeah.
And the Arunachal Act, I am not appearing, my lord. I am appearing the Assam Act.
Issue is the same.
My lord, I am not aware the Arunachal Act difference, whatever. But issue mainly, I think
This is
the
issue.
legal
After-
issue should be same, my lord.
After this 9-month judgment, only these.
The legal issue should be same, my lord.
Yes. When Advocate General for this Arunachal will be available.
Lordship,
We don't have the instructions.
Lordship, about the date, next available date, I don't have the instruction of it.
At least hearing matters में तो इतना issue.
Lordship, I understand, Lordship.
We are fixing on 26th November. On that day, either you argue or whatever it may be. Ask the Advocate General to submit the reply.
The 26th, my lord, I will be out of station. If one day here, then, my lord, after 26th.
5th of December,
My lord.
5th of December. Just a minute. It will be 10th of December. 10th of December.
It may take, my lord, 2 days at least so that your also may continuation.
Yeah.
It may take 2 days at least, my lord, so that the continuation.
Consider it to 2 days, 3 days or in
Right.
one day, it can be concluded. Don't want to keep it pending for.
My lord, it's pending for a long time. In fact, 3 benches have heard it already. And after that hearing, long hearing, my lord, that ultimately, my lord, either the judges, my lord, the bench was not there, retired.
We want to complete it.
My lord, it has to be 17 matter are there. My lord, these are 17 all matters, my lord.
Well,
At one go, we just want to complete it. at one-
My lord, that will be better, my lord. I'm obliged, my lord.
Yes.
Item 26.
So the writ petition is filed by the revenue against the order dated 25/3/2020 as per the Leonard CAT laws. Lordship, this is the second round of litigation. Earlier, the respondent approached.
Ultimately, was appointed as the corresponding for that. Then the promotion that we quickly. In the year 2002. 2002 means. 2020 is just- And in 2014, one of the juniors in.
He was appointed as this
Lordship, he was appointed as
Inspector.
inspector law in the
in which year?
Lordship in 2000. He passed SSC exams in 1996, Lord.
2004, sir, 26.
2004,
Lordship.
2004, 26.
2000.
I'm giving that.
The 7th of June 2024, he joined.
7th of June.
June. 20th of June, 2003 was, he was recommended,
Appointment on 26/4/2024, and joined on 7/6.
2004. But the recommendation for appointment was on 20th June, 2003. Okay.
But say page 166, by which the representation of the present respondent was disposed of by the under secretary, page 166. The entire case has been reflected here. So order dated 25th March 2015.
Yes.
Merit laws.
Yes.
Merit. This order is being made in compliance of the order dated 24/12/2014 of the Honorable Central Administrative Tribunal Guwahati Bench in OA number so and so, the matter of Sri Anil Kumar Sharma versus Union of India. And the Honorable CAT Guwahati Bench by order dated in the matter of Sri Anil Kumar Sharma directed to consider and dispose of the representation dated 24/11/2014 of the applicant within a period of 1 month from the date of receipt of the order and pass a region order and region and speaking order and communicate the same to the applicant. Sri Anil Sharma, OBC rank number so and so, was selected for the post of Inspector Central Excise for Staff Selection Commission on the basis of 1996 examination. Sri Anil Kumar's representation dated 24/11/2014 has been examined. It is noted that he has raised the following ground for reconsideration of his journal allocation. One, I had selected and recruited to the post of Inspector of Central Excise through examination for recruitment to the post of Inspector CEIT etc. 1996 conducted the SSC on 28/4/1996, which was conducted on Central Link Zonal Scheme. But the Honorable Supreme Court, by its judgment dated 9/12/1996 in number so-and-so, Radhisham versus so-and-so, struck down the scheme of zone-wise selection and ruled that in future no such selection should be made on basis. Accordingly, a re-examination was conducted by SCC on 13/6/1999 on all India basis and after interview, and its final result was published in the year 2001, wherein SCC has prepared all India merit list of selection candidate and forwarded the same to CBEC for further allocation. But after receiving the all India merit list of selected inspector, the CBC had allocated them to different zones arbitrarily without giving them an option to choose their zones of posting, despite knowing fact that there is huge disparity in promotion among the different zones.
Yes,
And let's say page 167, paragraph 5.
yes.
On examination of the facts, this case in compliance with the direction of the Honorable CAT Guwahati bench, modified order dated so and so, it is found that on the basis of result of Inspector of Central Excise Income Tax 1996 re-examination, 25 candidates were recommended by SCC. The criteria of allocation of 1996 base was to allocate the neighboring commissionerates on the basis of domicile and nearest to his or her hometown in order of merit. The allocation was done in proportion of the vacancies in that zone, as percentage of the total vacancies and taking into account the domicile. Sir Anil Kumar Sharma, SLC number so and so, whose home address was Sultan Pokhar West, Porsiganj district, Aira, Bihar, was allocated Shillong zone. It was conscious decision of the board to make allocation of the candidates proportionate to the vacancies in the zone as percentage of total vacancies. The contention of Sri Anil Kumar Sharma that the allocation was made arbitrary is not correct. It is also stated that direct recruit inspector are selected on the result of all India competitive examination conducted by the Staff Selection Commission on the basis of an all India merit list. The selected candidates are allocated to one of the several zones cadres. Once the selected candidate for the post of inspector, Central Excise Preventive Officer of Examination are allocated to a particular zone, she gets placed in that zone in seniority list of the cadre in accordance with the provisions contained in para 4.1 of the notified recruitment rules, which states that each commissionerate shall have its own separate cadre unless otherwise directed by the Central Board of Excise and Customs. Paragraph 6, promotion to the next post in the zonal seniority basis and not on the all India seniority basis. The inspector who join in particular zone will get promotion in the zone only whenever vacancies arise due to superannuation, promotion or to higher cadre, higher grades, creation of new posts pertaining to particular zone cadre. As per the draft seniority list of Inspector Central Excise of Shillong Zone as on 22/8/2014, Sri Anil Kumar Sharma appears at serial number 352 of the seniority list, and the last officer promoted under unreserved category is Srimati Narinda Kharkongar, appearing at serial number 161, and her date of joining as direct deputy inspector is 13/6/1995. Hence, no inspector junior to Sri Anil Kumar Sharma has been promoted in the Shillong zone. In view of the above, since the promotion to the next post is on zonal seniority basis and not all India seniority basis, Sri Anil Kumar Sharma, inspector who joined in Shillong zone, will get his next promotion in that zones according to his zonal seniority whenever vacancy arises. And accordingly is repeated. So we are maintaining cadre on the basis of zones. There are 21 zones in the entire CBSE lot. And he was allocated Shillong zone. No junior to him was promoted till that lot. London Tribunal of CBSE page, order started page 15. Order starts from page 15 lots. And operative part is at page 49. Paragraph 47 lots.
Yes.
In view of what has been discussed in the foregoing paragraphs and ratio laid down by the Honorable Supreme Court, including CAT Principal Bench, as cited above, we deem it fit and proper to direct respondents, authority, more particularly CBSE, to take earnest initiative for streamlining the rules and regulations in case of inspector as well as superintendent in order to maintain equality and rationality with reasonableness and to diffuse the genuine heart-burning public deprivation amongst the employee in the matter of promotion. Respondents are of the view are to review the entire issue on the basis of principle that seniority of merit shall not be disturbed while making the next promotion to the employee, and to consider the case of the applicant for promotion to the post of superintendent by convening DPC, and if he is found fit, he shall be promoted to such post at least for the date of his junior. Sri Gyanesh Kumar was promoted ordinarily or ordered accordingly. The entire exercise shall be carried out within 6 months, so and so. So Lordship, when we are maintaining zonal wise seniority, and he is put in the Shillong zone, no, and Gyanendra Prasad is belong to other zone Lordship. And rule speaks, Lordship, as quoted by the authorities, Lordship, I am placing the rules, 4.1. 4.1 of the rules. Each commissioner shall have its own separate cadre unless otherwise directed by the Central Board of Excise and Customs. And till that, Lordship, we are maintaining zone-wise cadres, Lordship, in case of inspector. Yes. But if there is a direction of the BSc. It is a method. This is a letter dated 16 January 2003.
Yeah.
I'm directed to say that the question of declaring Chief Commissioner of Central Excise Customs as cadre controlling authority in respect of staff of Group B level had been under consideration of the Central Board of Central Excise and Customs. Hearing referred to as the board of some time, it has now been decided by the board that all the powers are presently being exercised by respective commissioner as cadre controlling authority should henceforth be exercised by the respective chief commissioner. However, there would be no merger or bifurcation of existing cadre. That is, the function of each cadre controlling authority shall be exercised separately and independently by the chief commissioner. This is implied that the independent entity of each cadre shall remain intact and unchanged. Under the circumstances, Lordship, the direction of the tribunal to consider the case of the petitioner is not sustainable, Lord. Unless the rule is there, Lord. So this is our case.
Yes.
Please, your Lord.
Yes.
My lord, the basic grievance of the petitioner before the tribunal was that although his selection was on all India seniority basis, but his cadre was allocated to Shillong on an arbitrary method.
And this first time, whatever the posting in Shillong zone was objected by you.
Yes,
When?
that was 2014.
That
When-
was so 2002 to 2004 to 2014, you remain silent.
No, the reason is that, my lord, during the 2014, the first set of promotions were made.
Whatever.
And then, my lord, it came to light. Then it came to light that because they maintained a zonal seniority list,
But
therefore,
this is the rule says.
no, my lord, I'm
rule
coming to,
says it.
I'm coming to it, my lord. The reason is that, my lord, the appointments were made, when the selection was made, the selection was to be made initially on zonal basis. That was,
Radhesham judgment,
yes,
that-
that was struck down by the Honorable Supreme Court.
Fine.
And since thereafter, the process of recruitment was undertaken. So it was a bona fide belief that the rules were,
Despite of these rules,
no, these rules came later, my lord.
No.
when
These came 2002.
2002.
The recruitment was in the year 1996.
But ultimately, the recruitment was completed in the year 2004.
Recruitment was completed in the year 2002 itself, but the appointments were made later,
Appointments, you joined the service on 2004.
2004.
2004.
2004.
These rules were in vogue at that time.
Yes,
And these rules specifically says the seniority will be maintained zonal wise.
zonal wise. Now,
You have not challenged the validity of this rule at any point of time.
no,
You have also not raised any objection regarding your allocation to the Shillong zone, as the other persons have contested or objected, and their zones were changed.
Yes.
You have never done that.
No, I made a grievance, my lord. I made a grievance, and therefore in the first round of litigation, which was not considered,
Yeah.
and therefore in the first round of litigation, the honorable tribunal directed
That's another thing.
that it has to be.
Have you ever objected before this promotion granted to one Gyanendra Kumar or whatever? the
Yes,
name is?
Gyanendra Kumar.
Have you, prior to that, have you objected regarding your this allocation of belonging zone or anything else?
No, my lord, the basic fact that it was a zonal selection made 2002 when I joined, the fact that it was basically a zonal selection made, that was unknown to me. Only when, my lord, my lord, that was because of the reason that my lord, that was because of the reason that the zonal selection was to be done away with.
Not aware of that, then it's okay. You can't take now recourse of this.
No,
We are-
even-
You are saying that you are not aware of the rules that can't.
No, my
be
lord, my
excused.
submission before your lordship would be, even these rules will not obstruct my way. It will not come on my way, my lord. My lord, I'm just explaining, my lord. The tribunal has considered this aspect of the matter. They put a reference of the rule before the honorable tribunal. The tribunal was alive to the issue that there is a set of rules in the name of these recruitment rules 2002.
And
Now-
without even setting aside that rule
No, my
or
lord,
quashing that rule, whether the benefit can be granted.
now there is in the rule, my lord, the wording is this, my lord, if I understand it correctly, my lord. The rule says that notwithstanding anything contained in sub-rule 1, the jurisdictional chief commissioner of central excise may, if he considers to be necessary or expedient in the public interest, so to do, subject to such conditions as he may determine, having regard to the circumstances of the case and for reasons to be recorded in writing, order any post in the commissionerate of central excise to be filled by absorption of persons holding the same or comparable post, but belonging to the cadre of another commissionerate. So therefore, what my
Oh, that will,
therefore, my lord, therefore, my lord, if today the chief commissioner wants, he can fill up a post in Delhi commissionerate by a person holding this analogous post in any other commissionerate.
Fine.
So that is the purport of this,
Subject to the conditions.
subject to the conditions, of course, and that has to be reasons for reasons to be recorded in writing. So therefore, this rule is not as such an absolute embargo on my allocation of zones.
That simply says this fortifies their claim that each commissioner is separate. That's why only this provision that a person from the other commissionerate can be absorbed in other
And yes, in other,
commissionerate, subject to such conditions and reasons to be recorded.
yes. And
It's altogether different. In fact, that doesn't mean that his seniority belongs to this particular zone, remain the same.
there, no, my lord, on the same situation, my lord, there are instances I have mentioned in the pleadings, my lord. Other persons who, as your lordship has said, other persons who had objected.
Sir, objected and then they changed,
Yes.
their allocation was changed. Have you ever objected?
No, that is the direction of the honorable tribunal now, that since this allocation was done arbitrarily, because he was appearing,
That allocation, now you question after 10 years, how can you question that allocation now? That's the sole thing, even though maybe you have some force in your argument that allocation was not fair or not or discriminatory. After 10 years, how can you raise
No.
this objection, sir?
now, Millard, I may just place the fact in this form, Millard. As on date, Millard, the applicant has already promoted to he has been already promoted to the post of superintendent.
When?
That was the
In
promotion,
Shillong, Joe?
yes. And that was 2017.
Okay, fine.
2017. Now, only thing that is surviving in the consideration of the respondents, sorry, Millard, the writ petitioner is that, Millard, whether they can give me consequential benefits of promotion because the cadre allocation was done wrongly. That is the only thing they have to consider now.
Whatever it may be, you just satisfy us that your cadre allocation, you can challenge the cadre allocation after 10 long years.
Well, to
So,
that,
the
to that,
other persons have immediately approached and their cadre was changed.
is that is a difficulty, my lord. That cadre allocation was
That is very fatal.
that was not challenged. That was not challenged. But the tribunal, my lord, if your lordship will kindly come to page 40, 47, 41, my lord. The tribunal has examined this aspect of the matter, whether in the face of the rules, my lord, there can still be a case for consideration. That-
Para?
Page 40, paragraph 38. May I just read it out to your lord?
Yes.
Our considered view is that the applicant was allocated to Shillong zone not as per his will, but at wish and will of the authority. The main problem arose because the allocation of zone was made without having any option, and further promotion was made on zonal basis, and in his zone, there are lack of sufficient promotional avenues.
Just a minute now, please pause. Now come to the para starts there. This page, at the start of this page,
Page 40.
if the employee is deprived of so and so,
Purely solely on the ground of allocation of zone,
just
this starts from page 39.
now these findings of the tribunal is contrary to the yes, para 27.
Page 36.
Yeah.
We make it clear that the applicant also failed to establish that there is a mandatory provision for offering option in regards to allocation.
And here, the tribunal is saying that since you have not granted him this opportunity or given him option, therefore your
So, my lord, I'm not on that, my lord. That finding of, my lord,
to examine the order of the tribunal.
my lord, I'm admitting to this extent, my lord, the observation in the later part is running contrary to the what the tribunal has observed in the para 27. But my submission before your lordship is this, my lord. What is the purport of the order of the tribunal is that, my lord, the respondents are now required to undertake an exercise to examine whether, in view of the provision which enables the chief commissioner to take a decision for reasons to be recorded, whether that benefit can be granted to me or not.
Have you have not applied for that, sir? Where was the occasion for the commissionerate offer? You have not even applied for that.
My lord, if your lordship will kindly consider my prayers which the tribunal has recorded at page 17.
Yeah,
At page 17, your lordship will kindly see what was my prayer before the tribunal.
yes,
The first prayer was to set aside the impugn order of 2015, that is by which my representation was decided.
page just
Page 17.
17.
Yes.
Yes,
Paragraph, the first paragraph.
the honorable please to set aside so and so.
Yes, 2015, that is the first order by which my representation was decided against. That the tribunal be pleased to direct the respondents to consider the promotion of the applicant to the post of so-and-so at par with his junior Ganesh Kumar of the same All India merit list as so-and-so and so-and-so, and other direct recruit inspectors of 2003 batch of Central Excise Delhi zone, at least to its effect from 3/2014, and with all consequential service benefits, including seniority in the cadre of superintendent of Central Excise Group B.
How this Gyanendra Kumar is junior to you?
That is,
On the basis of All India merit,
Yes,
that's altogether different.
yeah, I admit, my lord, it was all on the big, my lord, when the Honorable Supreme Court had struck down the selection, near,
In relation to only initial.
yes, so it was, so my lord, it was the,
Never question the Honorable Supreme Court has never said that you can't maintain the journal wise seniority for the purpose of promotion. This was not the
no,
mandate of the
true,
Supreme
my lord,
Court.
but
judgment in Adesham, sir.
as your lordship has put the query that why I remained silent for so long years.
That is one of the points, sir.
Yes, my lord,
And without even challenging the validity of this rule 4, whether such relief can at all be granted.
Well, my submission will be the subsequent part of the rule 4.1, 4.2. 4.2 leaves some room of,
For that, you have to apply, sir. For that, you have
well,
to
my
apply.
lord,
before
my
the-
lord, it is basically the same thing that the tribunal has directed.
Yeah.
My lord, it is basically the same thing the tribunal has
The
directed.
direction of the tribunal are very
Well, for page,
directly to promote it, even without even changing this.
No, my lord,
zone,
that's why, my lord, the question of promotion will not come, my lord. That's why I have made the submission that he already, possibly that escaped the notice of the Honorable Tribunal. 2017, he was already promoted. So the question of,
was not brought into the notice of the court, sir. The direction, if that was the case, then even though these direction not at all can be implemented, sir.
no, that's why, my lord, I said, at any rate, my lord, at the most, the consideration that the writ petitioners may give to me is that whether, in view of my promotion in the year 2017, the question of granting me consequential benefit of seniority in the cadre of inspector or, in the cadre of superintendent can be gone into.
Now, there is
Because-
another problem. In the Shillong zone, you were at the serial number 352 in the seniority list.
Yes,
The person last promoted was on the seniority list of 161 in the year 2015.
yes.
14. sorry. Now, what about those persons who are in between you and this 161?
No, my
What would
instructions,
happen to those persons?
my lord, my instructions that these promotions have been already made. That's why, my lord, I have also been promoted.
You have also been promoted.
Yes.
So what about that? Then those persons who are in between you and the person promoted, what relief?
No, my lord, if the department now considers my case
Yeah.
for change of my cadre,
Then he has to consider for all the this inspectors in the all over India.
well, the others have not agitated, my lord. Others have not agitated. In the past, my lord, some people had agitated, and whoever had raised the agitation, he had done it.
Which zone you want to go?
Well, that was Delhi zone because my immediate junior was placed there, and there are vacancies in Delhi zone. It is not that, my lord, something will befall upon them.
But what about the concept of bottom seat? It can very well impose that condition.
Well, that's why, my lord, I said. That's why, my lord, I say the direction of the.
As per this rule 2 of this rule 4, sub rule 2 of rule 4, they can place it at the bottom of the senior.
Well, that's why, my lord, I said, let them have a consideration of the matter, my lord. If they
This is
decide
not
one
even
way
your-
or the other, my lord.
This was not even your case. Before the
Well, my lord, your lordship is exercising 226 jurisdiction now.
Ultimately, we are simply reviewing this order of the tribunal. What you have not asked.
But that is why, my lord, I said in substance, my lord, in substance, if your lordship can clarify that part in paragraph 47, whatever the tribunal has directed, in substance, my lord, that boils down to the situation that.
That's very difficult. What they have said. In view of what was foregoing paragraph, ratio laid down by the Supreme Court principle so and so.
We deem it fit and proper.
Direct the respondent authority more seriously to earnest initiative to streamlining the rule and regulation in case of as well as so and so, so and so.
Well,
So amendment in the rules is suggested
well,
or directed even.
Well, this aspect I am admitting, conceding, my lord, that could not have been gone into because there was no challenge to the rules. Well, I am conceding to at that extent. Only thing is that, my lord,
Without even this striking down that rule, certainly if they put this struck down this rule and then said, okay, now frame the rules
yes, that could have been done. That could have been done.
without even though still it is in the statute book, and despite that they do this. How can it be?
No, your lordship can that's why I said, my lord, your lordship can clarify this, that this position that since the rule was not challenged, so that cannot be gone into. But at any rate, since the promotions have already been made, the respondents, the writ petitioner.
That would amount to again in tinkering with this rule, which is not even.
Your lordship
taken
will,
into consideration.
your lordship will leave it to be decided by them. If they decided it one way or the other, my lord, I can have my remedy. I can have my remedy. If they decided it in one way or the other. इस जोन में कहीं पे भी कंसिडर करके वो तो है तो उल्टे बोला Last submission, my lord. My lord, the tribunal has also passed a direction for convening review DPC. Well, all these perhaps have been done being oblivious to the fact that 2000.
Review DPC in respect of only one person.
Yes, well, all these have been done being oblivious to the fact that the person has already promoted, has been promoted.
This was not the consideration.
This was not the consideration. So therefore, my lord, in any case, if your lordship is going to allow this appeal, your lordship, read petition, my lord, your lordship may also consider aspect that if the tribunal can revisit the circumstances, my lord. Because these facts perhaps have been missed out entirely. That's all.
Your body language speaks more than your arguments. Order is up.
Much
Obliged. Obliged, my lord.
Item 27.
Yes.
May I please, your lordship? The petitioners filed a writ petition, my lord, stating inter alia that certain part and parcels of land belonging to their predecessor in interest were acquired for construction of my lord Governor House, that is Raj Bhavan. And eventually they filed a writ petition on account of non-payment of land acquisition compensation. In the writ petition, my lord, certain affidavits were exchanged, but however, no conclusive materials were produced before the Honorable Single Judge to the extent as to whether, my lord, the definite part and parcels of land belonging to the petitioners or not were acquired, and that was left open. And the Honorable Single Judge, by my lord, that order which starts at page 83, was pleased to dispose of the writ petition, thereby giving a leverage or leeway to the state respondents to carry out a verification exercise. And if in the verification exercise it is found that their claim is correct, then my lord, to release the compensation. This is the sum and substance of the matter. Thereafter, my lord, they filed contempt petition due to non-compliance of that order. And we filed, my lord, interlocutory applications before the Honorable Single Judge, my lord, seeking further time, since the records were too old. It pertains to the year, my lord, 1976 onwards. and a thorough exercise was done in the old record room, my lord. And after verification of the records, it was found that there are 3 ducts, my lord, descriptions of land. And out of 3 ducts, my lord, in only 1 duct, the name of the predecessor in interest, my lord, the name of the predecessor in interest of the petitioners had figured out. And accordingly, my lord, we filed a review application before the Honorable Single Judge. Honorable Single Judge said that since these are question of facts and you have brought new facts now for adjudication of the court, review court is not the appropriate jurisdiction, my lord, to adjudicate upon the matter. And my lord, a liberty was given to file an appeal, hence this appeal. Now here, Lordship will find, my lord, that there are materials which we have enclosed along with the writ appeal to show, my lord, that the award was passed way back, much long ago. And the money belonging to the predecessor in interest of the writ petitioners have been earmarked and that has been kept in a revenue deposit. And so far the other 2 ducts are concerned, they are not at all connected, my lord. So this is how the matter stands, my lord. And if, my lord, contrary materials are produced by the other side, my lord, then the matter would be defined. But at this stage, my lord, there are no contrary materials to what we have produced along with the writ appeal. This is how, my lord, the matter stands.
What about that money which is, you're saying that for a particular portion, she was of these predecessor in the of the earlier owners are entitled. What about that money?
That money is, yes, it is still available. It has been, it was kept way back, my lord. And other,
Now suppose if you you are paying them or we issue a direction to pay that money, what about the interest?
the interest, my lord, we have already, my lord, earmarked and kept it since they were not accepting, my lord. So therefore it was kept in revenue deposit. That is not under dispute. That is not under dispute. It is kept in revenue deposit. We have tendered. The state has tendered.
Yes. I thought
This one, and my lord, the money that has been earmarked, lordship will find in the award statement that is annexed to the memo of appeal at page 1, people 111. Page 111. There, lordship will kindly see at my lord serial number 2 on the left hand side. Page 111. That is a translated copy of the original award statement. My lord, on the left hand side, lordship will find Sri Saroj Kumari Chaudhary. Now, Saroj Kumari Chaudhary is the predecessor in interest, my lord, of the writ petitioners, under whom, my lord, the writ petitioners are now claiming compensation. And the amount, final amount, lordship will find, my lord, at column number 13, it is 51,120 rupees. It was calculated way back in the year 1976. And others have, my lord, collected their dues. All other persons have collected their respective amount of compensation.
in this review application, you said Only one person is collected, later on the other person is also collected.
So,
Three
my lord,
persons were there, na?
yes, they have collected.
No, in review petition, you said that only one is collected.
One, my lord, this one, my lord, that one lordship will find at page 104. Page 103 for that matter, my lord, Indian Tobacco Company.
No, that's not.
And one another person, yes, my lord, he has also collected.
Just
Prafulla Chandra Barua, yes, lordship is correct. Prafulla Chandra Barua, he has collected.
only one is,
Yes, he have collected.
for that plot of land, Saroj Kumari, compensation was fixed rate, out of these three patas, Nirmala Mehdi has already collected.
Yes,
Balance compensation, two patedars remain having so and so. So later on, one another has also collected.
no, my lord, only that much. Now, so far as the my lord claim of the writ petitioners are concerned, we have tried, my lord, we have been able to establish before this honorable court that on the basis of materials, that my lord, their part of compensation has already been computed and earmarked, and that has been kept reserved.
Yes.
This is how, my lord, the matter stands. Now it will be a disputed question of fact.
Wait. The land initially belonged to one Saroj Kumari lordship, my grandmother. She shifted from here. She's the owner of entire land, about 60 bighas. She shifted from 1961, settled Calcutta. She died in 1962. After her death, lordship, this land was acquired in 1975. Her daughter came down and tried to find out the particulars of the land acquisition process, but she could not do it in her lifetime because every time that the department says no records, no like that. Her only son, the physically disabled son, now who's the petitioner number one, petitioner number one, he ultimately found out in 2012 that the particulars of the land acquisition proceeding by which the land was acquired. Then he filed a writ petition, made a lot of attempts to get the compensation, having not found that. He filed a writ petition, lordship, in this court. And the writ petition, lordship, this honorable court directed the Deputy Commissioner, respondent number 4, to file the return in the writ petitions. That lordship will find it at page 69 of the. This is the affidavit filed by the Deputy Commissioner, Kamrup lordship, in reply to our writ petition, lordship. Lordship, kindly see page 70, para 4, the 11th portion. That with regard to the statements made in para 2 of the writ petition, the deponent says that as per record available in the office, Sri Saroj Kumari Chaudhuri, wife of late Shasan Chasas, is the recorded pattadar of the land measuring 19 bighas, 2 quarters covered by Dag number Shasan Chas, land measuring 15 bighas, 6 lessas covered by Dag number Shasan Chas, and land measuring 22 bighas covered by Dag number 121. That she was the owner of a total about 56 bighas of land, which was acquired. Para 4, lordship, of page 70.
Yes.
Lordship. May I repeat the para, lordship?
Yeah.
Yeah. Then with regard to statements made in para 2 of the petition, the opponent states that as per the record available in this office, the DC office, that Saroj Kumari Chaudhuri Sasanchas is the recorded pattadar of the land measuring 19 bighas and odds in Dag number Sasanchas, land measuring 15 bighas and odds Dag number 122, and land measuring 22 bighas in Dag number 121, patta number 1. The total land covered by the above mentioned 3 Dags is 56 bighas, 2 quarters, 6 lessas. That was Saroj Kumar, the owner of this land. was acquired for construction of the Raj Bhavan, right, LA case number 3775. But the land measuring 2 bighas, 2 quarter 9 lisa covered by dag number such and such, a gun has been acquired for construction of the quarters of Raj Bhavans, Lordship. So that is, it clearly shows that 56 because of my land, my grandmother's land was acquired. Now, Lordship, we kindly turn to next page, Lordship, para 6. Which regard to the statement made in para 4 and 19 of the writ petition, the Tribunal states that land records measuring 60 bighas, 0 quarter, 15 lesser, right, LA case number such and such, has been notified in Assam Gazette. That is, my land has been notified. Dated 1175. But as per the minutes of the discussion held on such and such date 1976 at the office chamber of the Chief Secretary to the Government of Assam, Dispur, regarding acquisition of land and building of Raj Bhavan Guwahati has been modified as some of the notified land were involved in ULC case. The proposed acquisition of other vacant land
That has
notified.
been noted by the learned single judge in the order passed by him.
Lordship, this is not this affidavit of the deputy tribunal.
Now their stand is that on re-verification or verification of the record, they found that so and so land was not in your name, it was in the name of ITC, and for that they have already paid the compensation. A small piece of land belonging to you with 2 other persons was acquired for that purpose, and for that purpose the compensation has already been deposited. What is the material in possession of you to control that situation?
No, they have stated now, Lordship, after disposal case, that 22 bighas of land under Dag number 121, which owned by Saroj Kumari, my grandmother, has been purchased by one Prafulla Chandra Barua in 1962.
Right.
And name was corrected. Image was in 1963. That is the only thing that we are suspecting, Lordship. That I have no land.
Sir, please kindly consider now this review order.
Lordship.
Review order passed by learned single judge 111/2021, wherein this grounds for review which they have moved in application has been taken note of.
Yeah.
So whether any material is available with you to control these facts?
That my material sector annexes, Lordship, that which were annexed to the deputy commissioner's affidavit clearly shows I am the owner of the land.
But
Now-
here now they have, after verification, they have.
So
got
let
these
them-
facts. Is there any material, any record available with you to control these facts?
They have to help me now, Lordship.
Sir, then
Now
you-
they are saying, Lordship, the government is saying that again, for the 1962 sold this land. Let them show that Lordship that sell it. It's in government position only. For our satisfaction.
That is now,
But just
you
because,
have to prove your case, sir.
Lordship,
You have to prove your case. Yes, certainly, there was an affidavit on the part of the, this, DC. But ultimately, yes, another file and another affidavit and, stating that this, which he has mentioned in the earlier affidavit was not correct and the correct position is this.
no, because the two affidavits are two different deputy commissioners, Lordship.
Different
And
concept.
the status report
But
also.
they have clarified it that earlier, yes, they
So,
filed this affidavit, but on re-verification, they found these records.
To let them show that records little further, so that sell
These,
it.
they
Lordship.
have, they have
We accept
already
it.
annexed, they have annexed the documents here.
No, they only is a copy of the Jamabandi, land record.
So what
Earlier
is
this-
Jamabandi, a title of a person reflects from Jamabandi only.
That we are doubting because the deputy commissioner also annexed the Jamabandi, where I was shown as full owner. My grandfather was shown as full, complete owner.
Show us that Jamabandi, obtain the certified copy of that Jamabandi, we'll see to it.
It is annexed by deputy commissioner, Lordship. We'll kindly see. Lordship, in the affidavit, they have stated. Second affidavit, Lordship will kindly see, that was by the subsequent deputy commissioner. At page 74. I read para. The deponent has already filed an affidavit in opposition in case such and such and such. In the course of hearing, the Honorable Court directed to produce the report on 29/2/2018, and accordingly, Circle Officer Guwahati Revenue Circle has submitted a status report on 23/2018 to the Additional Deputy Commissioner Kamrup Sassanichas. Honorable Court, by order dated 23/3/18, had directed to file an affidavit incorporating the above status report dated 23/2018. According to the deponent has filed this affidavit. The status report on 2018, they filed it, Lordship. The deponent stated as report of the Circle of Sassanichas Revenue dated 23/18. It has been stated that on the basis of spot verification done by the employee of the revenue branch, Raj Bhavan, is situated on the plot of land village Kharvili Moja Sassanichas under Ulubari Dag number Sassanichas. In the hand sheet, it is seen that Srimati Sarosh Kumari, wife of Radhakanto, is shown as the Pattadar of 432. As per aforesaid records, the area of land is 54.15 R. Copy of the later Sassanichas. The deponent stated against the application submitted by the petitioner seeking report of existence of land. The Circle Officer Bhai, later dated 21/3/18, submitted a report received from the Lat Mandal to the Additional Deputy Commissioner. In the report of Raj Bhavan, situated on the plot number Sassanichas, Kharvili, Ulubari, under 45, Dag number Sassanichas. From the hand sheet, the name of Srimati Sarosh Kumari, wife of Radhakanto, is seen as the recorded Pattadar. This is the status loss in 2020. They found it on the field verification. Now they are saying that no, your grandmother sold the land to one PC Bora and then 63 itself. So let them waiting for a certain position.
What
The show that sell it,
the
Lordship.
Lanet single, they are not doubted their version. It has simply said, you have not produced this record at the time of hearing the record, and that doesn't mean that you have, with due diligence, you have proceeded with the matter. This is what in the review petition, the Lanet single, they just said.
No, now this is the appeal, Lordship. We're dealing with the appeal. In the appeal say, Lordship, they say that you are not entitled to land. You have sold this land. Your grandmother sold it in 1962.
The fact.
But if that was the case, that was reported in 2063, the record corrected. Then why in 2018 they have shown my grandfather as the owner of the land? So we are doubting, Lordship, that let them show that sell it because my grandmother.
Yes.
The problem is that,
Until
Lordship,
and unless you produce some record contrary to this, simply because they said in so and so, ultimately.
only
they-
record say that copy
they
of the government.
themselves have again now said, okay, sir, that was not the position, this is the position.
No, Lordship, the problem is that it was the grandmother who died in after that.
But the problem
So
are
did the-
so many. Land was acquired in the year 1975-76.
Yes, Lordship.
No such attempt was ever raised for compensation. You are saying your mother was pursuing the matter from 75 to 87, 76 to 87.
Lordship.
And thereafter she expired, and Then only in 2014, for the first time, you have raised this objection. On this ground alone, sir, at least.
But no, it's a question of records, so even if you are delayed, but record will not
But
speak
the
like.
question of records says something else which you are claiming. That is contrary to your claim.
No, there is a contradiction between their own records, that's it, that on.
Sir, now just show us any record. Show us any record.
We can only show that is already annexed, that's copy of the Java on this. Because when there's a contradiction, let them, lordship, that we suspect a foul play. How that PC Borua has purchased 22 bighas of land in 1963. So if that record was corrected in 1962, how the deputy commissioner has filed the affidavit showing that I am wrong?
He has wrongly filed this affidavit, it appears.
So let them at least produce that sale deed, lordship.
Huh?
The sale deed by which supposed to have been sold.
Everything is recorded in the record of rights.
In the Jamabandi, lordship. The Jamabandi is the two sets of Jamabandi, lordship. Therefore, to clarify the doubt that we are suspecting, lordship. Let them show that everything is government's position. Once they showed the sale deed, that was. Lordship. It is filed by lordship that in affidavit of the deputy commissioner, lordship.
If lordship permits, what is being harped upon is with regard to DAG number 432. No, yes. Now, it is not the case of the petitioners at no point of time that that part and parcels of land under DAG 42 belongs to their predecessor in time. Kindly see the read petition at page number 40, my lord. This is what the Honorable Single Judge has also held. It is their read petition. They say, my lord, that they are, page 40, my lord. I am troubling my lord with all these pages. Page 40, paragraph number 3. This is their read petition. Paragraph number 3, that as per the said Jamabandi, following lands are shown. DAG number 3663, 121, 122. Our simple case is that, my lord, that they belong to, my lord, some parts of the land belonging in DAG number 3663 were owned. 432 is a different plot of land. .432 is altogether a different plot of land. It is not their case even. Now they are trying to develop a new case without there being any pleading on record.
No, lordship, kindly page 46, we have annexed it, lordship. Page 46. Annex 1, our repetition, lordship. The extract of the Jamabandi.
Yes.
Page 46. Timothy Sarus Kumari. DAG number 3663. Area of land 19 bighas 2 kathas. This is the position, lordship, in 2015. This is the extra Jamabandi which you have obtained in 2015. So we are only on 3 DAGs, lordship. 3663, 121 or 122. And all annexes clearly show that Jamabandis, that we are the owner of this land, recorded owners of this land. Now, this is also supported by the Deputy Commissioner in their affidavits filed in 2019 and 2017. Therefore, the situation has changed. They said you have sold this land in 1962 itself.
Yes.
Thank you.
Yes.
Just, for your lordship to go to page 21, that of the, their statement, which you are disputing, Lord. Page 21, para 2. Page 21, para 2.
Read.
Lordship. The subsequent to the aforesaid orders dated such and such, passed by the Honorable Single Judge, an exhaustive inquiry was conducted and it has been found that land measuring 22 bighas of Dag number 121, Patta number 45, years grant in village such and such under Ulubari Moja, which is in possession of Raj Bhavan, was mutated in the name of Prafulla Chandra Borua by Chita order such and such, dated 25/7/1962. Record of which has been corrected in 2010-63. The total area of land covered by Dag number 121 is 22 bighas, and the entire plot of land under Dag number 121 is mutated in the name of Prafulla Chandra Borua, which is supported by a certified copy of Sarwar Jamabandi, dated 3/1/2019. And as such, late Sarosh Kumari Chaudhuri can have no claim over the land covered by Dag number 121. Now, this is annexed at page 93, the copy of the Jamabandi. Okay. Lordship, Sarosh Kumari, got it, page 93, Lordship.
Yes.
Annexed.
Yes.
93, Lordship, this is pertaining to this land, Dag number 121, and right-hand side column. As per order dated 25/7/1962, passed by ASO in surveyed Sitan Session measuring, land measuring 22 bighas has been mutated in the name of Prafulla Chandra Borua in respect of Dag number such and such old 121 new in place of Pottadar Bharshut, in place of Pottadar by Bharshu purchase. Lordship, let them show that the sell deed, Lordship. This is the only thing we are doubting.
Have you challenged this entry at all? At any point of time?
We have come to know only now only, after that was, there was
So challenge that then, why to appeal against this mutation? Keep me interfere.
because now the government is in advantage position. All government records all along saying this was owned by my grandmother. But now they have come suddenly, the same government. Record says this is no, it was sold by your grandmother in 1962. Let them satisfy, let them show that sell the copy of the sale record. In that case, this is where foul play is being we are suspecting a foul play.
all.
Your lordship, that's unless and until this point is inquired. So allowing the writ appeal will cause serious prejudice to the petitioners. Yes.
Order is up.
Obliged.
I'm so obliged.
Item 38.
Your Lordship, wait for the petitioners, but the arguing in item number 12. In court number 12. So if your Lordship, maybe please.
Adjourn 10 weeks.
Item 39.
Lordship, in this case, I have obtained some records
Yeah.
regarding their three applications. That I'd like to file a short affidavit by enclosing all these records, which will be very relevant. And the other point, Lordship, which was of Lordship's concern the other day, how a individual cannot apply. So that, Lordship, I'll take instruction. Maybe we'll have to rectify it, Lordship. Prima facie, it is not correct.
Only you can't restrict.
Yes, Lordship. I fully. So let it come after 2 weeks or so. In the meantime, I will consult with the concerned person of the government, Lordship.
Mr. Pansal, then by and large, your whatever the grievance, that only that agency or whatever it may be farm registered under so and so they can apply. But yes, any individual can apply if they make such provision. If any individual can apply, and then his application would be considered as per the
Lordship.
whatever the facts you have brought into or as per their verification or inquiry or whatever.
Madam, that is one thing, and with due respect. Second aspect is that, madam, they have rejected the application because I did not apply it for the purpose of husbandry or animal husbandry or agriculture. Now, the act is very clear. The purpose for trade is also one of the purpose.
So that is, if that decision, if you are aggrieved by that decision, then you can very well challenge it by way of writ petition.
Madam, therefore, I challenge here also.
Here, but here
I challenge here also.
the principal question regarding this is that whether that provision restricting the
That is all, madam.
right to application
My lord.
is constitutional or not. That is
Yes,
what the
that is one of the main ground.
that's the main ground, and
But-
if
and
they are
second-
going to rectify it,
My lord. But even if, my lord, even if, by due respect, even if they rectify the first argument, allowing the citizen to apply.
Yeah.
Second purpose of the rejection, the ground of rejection by the authority clearly mentioned that I'm not eligible to obtain the permits because of the
that's why only
purpose, madam.
that's why only that process, whatever it may be, that's why only we ask them.
My lord,
That to
what
do
will
some
happen?
material on record on the basis of which he has
Madam.
recorded this, that he is not so and so produce any material on that.
Madam, what will happen again? After rectifying, my lord, I may be allowed to apply. And they may reject on the same ground, saying that I'm not applying for the agriculture or husband. Now, the trade is very clear, madam. might just take the petition.
Let them come with that, then we'll consider it.
My lord,
Let them
I-
come with the proposal of amending or this,
my lord,
removing this clause, then we'll consider.
my lord, with profound respect, my lord, may I just draw a lord's attention to page number 49 on
49.
49 of the petition. This is impugns of the IGL angels.
Yes.
The ground of rejection, my lord, is, my lord, here. In view of the above, it is declared that permission as prayed for could not be issued by the undersigned considering your transportation of cattle from West Bengal, is not for bona fide agriculture.
That's right.
And,
That is
so,
always questionable, and that you can challenge by way of writ petition.
but, and the,
That these decisions, whatever, is not based on any evidence or whatever it may be.
and the purpose of a trade is one of the acceptable purpose under the act. What you kindly page number, you kindly see, page number 63 only,
Yeah.
but 63.
Yes.
First amendment, my lord. Clause 4, at the bottom, my lord, notwithstanding anything contained in subsection 1, 2, and 3, the competent authority may issue permit to any
That we have
agency.
already considered, and we are saying this, this prima facie we are is not acceptable, and he, learned advocate general is saying we are going to change it.
My lord, we great respect, my lord, I can see to that, but second, what they are missing is the purpose. Even they rectify that one, they will reject me on the same ground, because they are ignoring the purpose. Lord, you kindly see the page number 64.
On the same ground, which ground?
On the same ground of my lord, Lordship, agency register under the Animal Husbandry within the Department of some for purpose of cattle for bona fide agriculture or animal husbandry purpose, or for transportation of cattle for trade. Now I applied for trade. They rejected me, madam. They could have considered me this.
Okay. Have you annexed the rules?
But the compilation, my lord, I have made the compilation. Let us submit.
Give us.
Thank you. Excellent. my lord, the principal act is found in my lord, page number 4.
Rules.
The rules may come straight with the rules.
Page 2.
Page number 20, ma'am. Page number 20. Rule 6, my lord.
amended.
Sekia, have you filed any affidavit on behalf of the state?
We have filed. We have filed. We have filed. In fact, we have filed two affidavits. Three.
What is the meaning of this, sir? This rule 4, section 4, which they have now is amended, page 63.
Yes.
My lord, in state affidavit is page number 72.
No, just a minute. Mr. Sekia,
Lordship.
this page 63.
Amendment to section 7(4).
Yeah.
In the principal act in section 7, subsection 2 in third line in between the words state.
No. Notwithstanding anything contained in the subsection 1, 2, and 3, last line.
Yes,
This
row 4. Notwithstanding anything contained in subsection 1, 2, and 3, the competent authority may issue permit to any agency or firm. Earlier, person was also there, registered under the Animal Husbandry and Veterinary Department, Assam, for transport of cattle for bona fide agriculture or animal husbandry purpose, or for transportation of cattle for trade. For the said purposes may be prescribed in the rules framed under this act.
What the said purposes means you have restricted only the person who is transporting for agriculture and animal husbandry purpose, then only it can be granted, not to a trader. Suppose in his case, he is saying that I'm purchasing some animal
Lordship.
from West Bengal and transporting it to Meghalaya.
Lordship.
Then for that purpose, you will not grant them.
If we look at the strict meaning, Lordship, it is yes.
That is, can protect a person, because yes, it is there, but if he is transporting it to the West Bengal to Meghalaya,
Lordship.
he is simply a transporter. And he handed over this cattle to a person in a Meghalaya or even in Assam. Now he is
No, he is not a transporter, Lordship. He is a trader. He is not a
trader.
trader.
For that purpose, suppose he is purchasing some animals from this
Yes, now.
West Bengal and selling it to in other states.
Yes.
For transporting those cattle.
That is not an issue. The issue is, Lordship, whether he is transporting it for trading purpose, and if he supplies those cattle or the cows to a slaughterhouse for trading purpose. Our whole intention is to follow the mandate of Article 48 of the.
Sir, whatever it may be, he is simply seeking a permission to transport those cattle through the state of Assam.
And we have to ensure that if it is for the purpose of trading relating to animal husbandry and agriculture, suppose he is carrying these cows to give it to a farmer for agriculture purpose, then it is no difficulty.
And if he transported it for the purpose of selling the
Cows.
Cows or whatever it may be,
Yes.
In the market.
In the market.
Then
that is also permissible if it is for agriculture.
That's it. It restricts only for that purposes of how he.
Yes.
How a person or trader know that the person who is purchasing the.
That is where we are verifying what kind of trade he is into.
Using for that, what purposes?
That is why we are ensuring what purpose in trade.
How a trader can know, sir? How a trader who is transporting who is selling a cattle in a.
Basically,
okay.
what we are saying that if a farmer is transporting it, I am a farmer in Meghalaya. I want to buy some cattle
Yeah,
for my agriculture purpose.
yes.
He can very easily establish it.
How can it be established? Sir, he knows in open market, he is not going to.
No, he is because he is for his own use, for agriculture or animal husbandry, for breeding. That is why our form C says it is for breeding or agriculture. Form C, if Lordship is pleased to look into.
If you are saying that he has to first verify that he is only transporting only or is selling this cattle only for the animal husbandry or agriculture purpose.
Yes, Lord.
Then
That is the intent of the act.
that is
If the intent
of the
is
act, then
permissible,
no such intention is there in the rules itself. Sir. The rules.
yes, that is why the purpose of transportation, we have 3 columns here.
Yeah.
For farming slash draft purpose, then milching oblique breeding purpose,
Where is that?
the form
Form number
C.
Form C.
Form C. Application for permit, transportation of cattle for bona fide agriculture or animal husbandry purpose.
Purpose of
D.
transportation.
Any other reason, please specify. So he specified it as trade. So he will have to,
He'll have to.
he have to establish, he have to satisfy that that trading is for the purpose of animal husbandry or agriculture.
And how can he is a trader? How can he know that the person is
thing which
transporting to the cattle market? How he knows what the purchaser would do with
Yes,
the cattle?
if he is selling in a cattle market, then he will show us a trade license that he is a seller, he is an authorized seller.
So there is that condition.
That condition he have to satisfy.
No, sir, there is that condition in the rules that if only a trader having a license can apply for that. Where is that condition?
That is why you have to satisfy the officer.
Act or rules, sir.
He just say that I am a seller, I will go and sell it.
Sir, form number G. This is a certificate for sale and purchase of animals in the animal market. It also doesn't say that the person has to specify that for what purpose he is purchasing the animal. The one hand you are saying that is we will restrict only for this transportation or trade or whatever may only for the animal, this husbandry, something else.
Agriculture.
Where you have set up the animal markets. So animal markets may if the person is going to
Animal markets, Lordship, if he has to sell it in animal markets, he must have some credentials as a trader to do business in.
It is not there in the rules and this act and the rules, sir.
That point also, I will address that point also after taking instructions, Lordship, whether that can be inserted, if that is the only lacuna. Otherwise, our intention is to restrict persons from allowing these cattle to go into slaughterhouses without authorization.
This means if we are restricting only to this purpose, then it means this restricting the
Which is permissible, Lordship.
right of trade, sir. That is, you are restricting it.
Certain things we can restrict, Lordship. We have a mandate.
Reasonable restrictions certainly
Yes.
permissible, but it seems that it is unreasonable. Only to the trader,
There are two parts.
he has to satisfy that he is selling this only for to a person who will use for agriculture or animal purpose, this agriculture or husbandry purposes, sir, that would be very difficult for any trader to disclose how he knows that what the purchaser would do.
That is why we have that subsequent, because the first permit he may get, but the second permit he have to ensure that. If you look at the scheme of the rule, I'll just. For his subsequent purpose, he have to show the utilization also. কোনটো?
It is fine, you have to see it, this is, it amounts to putting restriction on the right to business, sir. Because a trader, you can't expect a trader that he has to, first he is satisfied that I am doing this trading and the person who will purchase this cattle will only use for this purpose, that amount.
First, he will have to establish that he is a trader. He is a genuine trader.
Suppose even a person, genuine trader.
Trader means, Lordship, why I am saying, Lordship,
Yeah.
he cannot satisfy also that he is not, he is a trader.
The trader, where is the?
If you have to produce the
In the
trade
animal-
license,
In the animal market, if a person goes to sell this or purchase a cattle in the animal market,
Because-
where is this condition that only the trader to whom a license is issued can only do this business? Where is that, sir?
our law is very clear, Lordship, that
Your law is.
he has to be a trader and his trading is relating to animal husbandry and agriculture. If that is against the law, then Lordship will definitely set it aside. But
Nima, okay? In Form C also, you are not asking for trade license.
we are not asking, but he have to, because if he's fulfilled the first two conditions, then he don't have to go for the additional one.
So that is very impossible for any trader to at least satisfy you on this aspect. For a trader, particularly for a trader.
The trading also, Lordship, is very clear.
Sir,
the trading is,
you can restrict a person on a seller or this purchaser that if the person can't sell it for the slaughtering purposes or can't purchase it for that. But so far as regarding a transport who is a trader, how can you restrict his right to be?
that is why, Lordship, our line is very clear. He should be a registered trader. When he,
It's a registered trader, where is that condition that only those persons who are
and
registered?
here we have said, we have indicated that every farm and agency have to register, get registration here. But the individual, Lordship, he will also have to register later on.
Sir, in rule, again, if you point out permit for transportation of cattle. What you are saying, only issue permit to any agency or farm only? No person is there?
Initially, the person was also there. In the amendment, the person was.
Restricted it only to those. Or rules में आप क्या कह रहे हैं? What you are saying in the rules, permit for transportation of cattle, a person or agency or farm, a person, again you have introduced that person here.
Maybe there was some inadvertent mistake because the rule has also to be amended, actually. But now we'll amend the act by inserting the person again.
Can you please, whatever the amendment act, clarify this, sir? You
Will
can't
clarify,
restrict
Lord.
the trade.
To become a trader, to be a trader in the line relating to trade of animal husbandry and agriculture purpose, Lordship, what are the requirements they have to ask for?
What are the requirements? What requirements you have said that this person should be treated as a trader? Where is that, sir? That is missing. That is not there in the act of the rules.
Let me get back to on this, Lordship. একটু করে থাকিব দিয়া মন এই কিন্তু রেভিনিউ তোমালোকে বিক্ৰী নকৰা হস্পিটেল নহয় মোক অৱস্থা এইটো কাগজো নিদিয়ে টাইমত হ'ব তোমালোকে কোনো এনেকে কেছ কৰিব লাগে অফিচাৰো নাজানে তুমিও নাজানা বিচাৰিও নাজানা help to center company ke bonande enege full payment kole file
There are many things we have to answer. sir.
lordship.
You have to answer many things. You are at one hand, you are permitting this beef and all. And again, you are saying for slaughtering purposes, we will not allow particular ticket. That's right.
We have two things, lordship. The objective, maybe it is not drafted in the proper manner. Our objective is to restrict the smuggling of cows from Assam to Bangladesh. That is one major area. The other one is to restrain
Then
slaughtering as much as possible, which is directly we are taking the
slaughtering is not at all banned, sir.
the slaughtering is permitted in a regulated manner.
Then for that purpose, sir, how can you say that a trader can only for the animal? Even though he can transport the vehicle for the purpose of slaughtering also. And for that he needed a permit, sir. When the slaughtering
They will
itself
not
is
declare that. The
permitted in
problem is that they are not going to declare. That is the issue. If it is, if they come up with open and clean hands, lordship, the things would have been different. But anyway, lordship, I'll satisfy.
The prohibition of slaughtering without certificate from competent authority. If a person is having a certificate from the competent authority, slaughtering is permitted.
If he brings that, where is the problem?
Sir, he is not for, he is simply transporting the cattle.
No, he is not simply lordship.
Yeah.
Lordship, we have to read certain things beyond.
Sir, beyond the, at least you should have some material for that.
That is why
Place the
the
material.
rules was not properly drafted. Maybe we'll look into it and we'll get it rectified, lordship. No difficult.
When?
Let it come in the first week of December, lordship.
You have to answer many questions.
Lordship.
You just
Whether we can put this restriction on that, we can, lordship. But maybe the format is not proper. We'll rectify it. We'll modify it.
Even we have taken the ground that the act was passed in violation of the Article 304P. 304P says that the prior sanction from the President of India is required to bring this legislation. We have taken that specific ground. State is not denied. So in the act itself
304, it will not be
Act
within the
itself
304. It will be under Article 48A.
you look into the.
Our source is 48.
You just look into that, you will find
Lords.
questions to be answered.
Lords.
First week of December.
Keep your.
Yes.
May I beg to mention?
My lord, 4th December, if lordship permits me.
Third hearing day.
Right.
3rd or 5th?
3rd.
3rd of December.
Third.
Deeply
Deeply obliged.
Yes,
Lordship, I beg to mention item 43.
Yeah.
I have some difficulty at 2 o'clock, your lordship. If it can be next week, your lordship. I informed my side, they have some difficulty on these days.
if you inform me.
Item 44, lordship. I'm in the midst of two part-heard matters. Whole morning I was there. So I'm not fully prepared in item 44. Could it be taken up tomorrow also? Lordship?
Another matters are also there in which you are appearing. It is item number 2 and 3.
2 and 3, either me or my colleague will appear and complete it, lordship. Or maybe tomorrow as the first item, lordship.
Tomorrow, though, not possible. 2 and 3, in fact, they are going urgency.
Then we'll do at 2 o'clock, 2 and 3, lordship. Item 44 may come up any other.
They begin it in the suspension law. But there being no stay order. Again, our suspension has been extended your lordship, but there being no stay order.
Item 2 and 3.
So I can see.
44 may be taken up tomorrow, lordship.
Monday.
Monday. Highly obliged.
Pass over matter 2 and 3.
Lord, actually, I completed my argument. My learned friend was to place the state's perspective. There are 2, 3 other judgments, whether I'll place now or together I'll be at the time of replying. Place it now.
As you wish. As you,
Yes.
yes.
My lord, on repugnancy, my lord, I'll rely upon one judgment. That is 2013 2 SCC 617. My lord, 2013 2 SCC 617, Ma Vaishno Devi Mahila Mahavidyalaya versus State of Uttar Pradesh. My lord, I'll rely upon paragraph 59 and 60. It is again, my lord, vis-a-vis NCT prescription. Lord, may kindly come to page 647, para 59. The above enunciated principles clearly show that council is the authority, that is NCT, constituted under the Central Act with the responsibility of maintaining education of standard and judging upon the infrastructure and facilities available for imparting such professional education. Its opinion is of utmost importance and shall take precedence over the views of the state as well as that of the university. Department of the state concerned and affiliating university have a role to play, but it is limited in its application. They cannot lay down any guideline or policy which should be in conflict with the central statute or standards laid down by the central body. The state can frame its policy for admission to such professional courses, but such policy again has to be in conformity with the directives issued by the central body. In the present case, there is not much conflict on this issue, but it needs to be clarified that while the state grants it approval and university is affiliation for increased intake of seat or anyway, this was on the facts of this case. Now, the principle of law has been laid down in placidum, D, E, and F. Then my lord will kindly come to para 60. NCT has been enacted by the parliament with reference to Schedule 7, Entry 1, List 1, Entry 66 of the Constitution. There is no such specific power vested in the state legislature under Schedule 7, List 2. Schedule 7, List 3, Entry 25 is the other entry that provides the field for legislation both to the state and the center. In relation to education, including technical education, medical education and universities, vocational and technical training of labor. The field is primarily covered by union list and thus state can exercise any legislative power under list 325, but such law cannot be repugnant to the central law. Wherever the state law is irreconcilable with the central law, the state law must give way in favor of the central law to the extent of repugnancy. This will show the supremacy of the central law in relation to professional education, including teachers training program. In Medical Council of India versus State of Karnataka, this court had the occasion to discuss the conflict as follows. The State Act, namely the Karnataka University Act and Karnataka Capitation Fee Act, must give way to the Central Act, namely Indian Medical Council Act. Karnataka Capitation Fee Act was enacted for the sole purpose of regulation in collection of capitation fee by the colleges, and for that, state government is empowered to fix the maximum number of students that can be admitted. But that number cannot be over and above fixed by the Central Medical Council as per the regulation. Chapter 11(9) of the Karnataka University Act, which contains provision for affiliation of colleges and recognition of institutions,
applies to all types of colleges and not necessarily to institutions. Sorry, not necessarily to professional colleges like medical colleges. Subsection 10 of section 53, falling in chapter 9 of this act, provides for maximum number of students to be admitted to course for studies in a college, and that number shall not exceed the intake fixed by the university or the government. But this position has again to be read subject to intake fees by the medical council under its regulation. It is the medical council which is primarily responsible for fixing standard of medical education and overseeing that these standards are maintained. It is the medical council which is the principal body to lay down the conditions for recognition of medical colleges, which should include the fixing of intake for admission to medical college. We have already seen in the beginning of the judgment various provisions of the Medical Council Act. It is therefore the Medical Council which in effect grants recognition and also withdraws the same. Regulations under section 33 of the Medical Council Act, which were made in 77, prescribe the accommodation in the colleges and its associated technical hospitals and teachings and technical staff and equipment in various departments in college and in the hospitals. These regulations are in considerable detail. Teacher-student ratio prescribed is 1:10, exclusive of professor or head of the department. Regulation further prescribed, apart from other things, that number of teaching bed in attached hospital. Anyway, my lord, the proposition which emerges from these authorities are, my lord, it is the Medical Council or it is the NCTA, my lord, which has the primacy in the matter. The moment state acts contrary to it, my lord, then it is the central prescription or NCT prescriptions which will prevail. Now, my lord, there is one judgment of the Supreme Court where the, my lord, the Honorable Supreme Court has summarized the situation when repugnancy takes place. That is, my lord, 2018 1 SCC 407. So it was a case squarely covered, my lord, in my humble submission. Now, para 51.8 and para 51.10. These are the two paragraphs I'll rely, my lord. 2018 1 SCC 407. Innovative Industries Limited versus ICICI Bank. My lords will kindly come to page 460. Different situations has been visualized, but I respectfully feel, my lord, 51.8 and 51.10 will cover our cases. A conflict may arise when parliamentary law and state law seeks to exercise their power over the same matter. This need not be in the form of a direct conflict, where one says do, the other says don't. Laws under these head are repugnant, even if the rule of conduct prescribed by both law is identical. This test that has been applied in such cases is based on the principle on which rule of implied repeal rests. Namely, if the subject matter of the state legislation or part thereof is identical with that of the parliamentary legislation, so that they cannot both stand together, then state legislation will be said to be repugnant to the parliamentary legislation. However, if the state legislation or a part thereof deals not with the matters which are formed the subject matter of the parliamentary legislation, but with other and distinct matters, so though are cognate and allied nature, there is no repugnancy. So question is, my lord, an aspect of implied repeal is also involved if the state law is contrary to the central prescription. Now, 51.10, my lord, the only exception has been carved out. That's very important. It is only when, my lord, 254(2) is followed, then only it will form in that excluded category. The only exception to the above is when it is found that a state legislation is repugnant to the parliamentary legislation or an existing law, if the case falls within Article 254(2) and presidential assent is received for state legislation in which state legislation prevails over the parliamentary or an existing law within that state. Here again, the state law must give way to any subsequent parliamentary law
which adds to amend, varies or repeal, and law made by the legislature of a state by virtue of the operation of Article 254(2) provision. So, my lord, only exception if the bill is reserved for assent of the president, in which case state law will prevail. So, therefore, law seems to be well settled, my lord. It need not be informed. The moment it is irreconcilable, in my humble submission, my lord, then it will be a case of repugnancy. My lord, nowadays, my lord, apart from my lord, nowadays, apart from the grounds of violation of Article 14, violation of fundamental rights against public policy, a new concept called, my lord, manifest arbitrariness has been added as one of the judicial grounds of judicial review against legislation. And I will respectfully submit, my lord, here is a case, the amendment suffers from the vice of, my lord, manifest arbitrariness. I'll just rely on two decisions on this point, my lord. The first decision on the point is the Justice Putuswamy judgment, my lord. 2017 10 SCC, page 1, para 294 to 296. My lord will kindly come to page 496, para 294. Page 496. The court in the exercise of its, I'm sorry, page 496, para 294. The court in the exercise of its power of judicial review is unquestionably vested with the constitutional power to adjudicate upon the validity of a law. When validity of a law is questioned on the ground that it violates a guarantee contained in Article 21, the scope of challenge is not confined only to whether the procedure for deprivation of life or personal liberty is fair, just, and reasonable. The substantive challenges to the validity of the laws encroaching upon the right to life or personal liberty has been considered and dealt with in varying contexts, such as death penalty, Basant Singh, mandatory death sentences, Me Too, among other cases. A person cannot be deprived of life or personal liberty except in accordance with the procedure established by law. Article 14 as a guarantee against arbitrariness infuses the entirety of Article 21. The interrelationship between guarantee against arbitrariness and protection of life and personal liberty operates in a multifaceted plan. First, it ensures that procedure for deprivation must be fair, just, and reasonable. Second, Article 14 impacts both the procedure and expression law. A law within the meaning of Article 21 must be consistent with the norms of fairness which originate in Article 14. As a matter of principle, once Article 14 has a connect with Article 21, the norms of fairness and reasonableness would apply not only to the procedure but that is to substantive law as well. Above all, it must be recognized that judicial review is a powerful guarantee against legislative encroachment on life and personal liberty. To cede this right would dilute the importance of protection guaranteed to life and personal liberty by Constitution. Hence, while judicial review in constitutional challenges to validity of legislation is exercised with conscious regard for presumption of constitutionality and for the separation of powers between the legislative, executive, and judicial institution, the constitutional power which is vested in the court must be retained as a vibrant means of protecting the lives and freedom of individuals. The danger of construing this as an exercise of substantive due process is that it results in incorporation of a concept from the American Constitution, which was consciously not accepted when the Constitution was framed. Moreover, even in the country of its origin, the substantive due process has led to vagaries of judicial interpretation. Particularly having regard to the constitutional history surrounding the deletion of that phrase in our Constitution, it would be inappropriate to equate the jurisdiction of the constitutional courts in India to entertain substantive challenge to the validity of law with exercise of substantive due process under the US Constitution. A reference to substantive due process in some of the judgment is essentially a reference to substantive challenge to the validity of law on the ground that its substantive as distinct from procedural provision violates the Constitution. So, my lord, not only that procedural part, even the substantive part also can be gone into. Therefore, my lord, manifest arbitrariness in one facet, which has been added as one of the grounds for judicial review. My lord, my last decision on this point is 2021 5 SCC, page 1. This is again on manifest arbitrariness, 2 paragraphs, my lord, 59 and 60, where the Honorable Supreme Court, after taking note of my lord Kutuswamy, Naptes, then my lord Joseph Saini and all, page my lord 61. The seeds of this idea had a mutated growth. It was in the decision of this court in Royappa that this court laid bare. I'm sorry, Miller. Hello, 2021 5 SCC, page 1. Yes, beloved will have page 61, para 59. The seeds of this idea had a mutated growth. It was in the decision of this court in Royappa that this court laid bare a new dimension in the majestic provision of Article 14. This court took the view that arbitrariness and fairness are sworn enemies. Guarantee of Article 14 is not confined. In other words, to its prohibiting a prohibition against equals being discriminated against or unequals being treated alike. State action must be fair and not arbitrary if it to pass muster in a law, in a court of law. It is essentially following the dicta laid down as aforesaid that this court in Sairavanu, wherein one of us, speaking for the majority, held as follows. It will be noticed that a constitution bench of this court in Indian Express stated that it was a settled law that subordinate legislation can be challenged on any of the grounds available for challenge against a plenary legislation. This being the case, there is no rational distinction between the two types of legislation when it comes to this ground of challenge under Article 14. The test of manifest arbitrariness, therefore, as laid down in the aforesaid judgment, would apply to invalidate legislation as well as subordinate legislation under Article 14. Manifest arbitrariness therefore must be something done by the legislature capriciously, irrationally, and or without adequate determining principle. Also, when something is done which is excessive and disproportionate, such legislation would be manifestly arbitrary. We are therefore of the view that arbitrariness in the sense of manifest arbitrariness, as pointed out by us above, would apply to negate legislation as well under Article 14. This view, namely that, be it a plenary law, if it is found to be manifestly arbitrary, it becomes vulnerable, has been followed in the following decision amongst others, Napthes, etc., etc. So, my lord, now it is well settled ground of judicial review that is manifest arbitrariness. So, on the ground of manifest arbitrariness, even a legislation can be negated, my lord. So these are my submissions, my lord. I reserve my right of reply, subject to what my learned friends say.
May it please your lordship. So what I could gather from the submission of the writ petitioner's lordship, that they want these two amendments. The first amendment, lordship will find at page 62 of the two amendment, page 58 of the writ petition, Moni Gogoi 1414 of 2024.
68.
658, 58.
58.
So they are challenging the notification dated 28 September 2023,
Yes.
by which the state of Assam in exercise of power under 309 has amended the Assam secondary education rules, amendment of rule 8, where 8.1 is now being substituted. 8.1 says the recruitment to the post in the cadre of postgraduate teacher and graduate teacher, including subject teacher, in vocational subjects shall be made by direct recruitment to the teacher's eligibility test cum recruitment test, hereinafter called TAT cum recruitment test, to be held as per criteria mentioned in Schedule 2 and in the manner hereinafter provided. So they are basically offended by this new concept of TAT cum recruitment test. 2, 3 also they have challenged, and also they have challenged the subsequent second amendment by which page 62 substitution of schedule 2, here there are some markings regarding a teacher's recruitment test, 140 marks in the following papers, then NCC sports, etc. And Roman 2, lordship will kindly see, candidates who have passed the earlier high/higher secondary TAT and not being appointed till date will get weightage of 5% of marks secured in the respective TAT, or maximum 5 marks for selection as a graduate/postgraduate teacher. So these two provisions under two notifications are put to challenge. Their basic ground is that on two fronts. The first front is, lordship, that we cannot go beyond the norms as prescribed by the NCTE. That is a central legislation. And number two, even if we go, then there is a conflict and we have to take the assent of the president under Article 254(2). These are the two things. Now let us see what NCT is all about. What NCT is saying. One thing, this is going undisputed, that so far as secondary education is concerned, there is no prescription of TET for the secondary level teachers. for the elementary levels teachers under the RTE Act, plus a notification issued under section 23 of the RTE Act, elementary education teachers must have TET qualification at their recruitment level. So far as secondary level teachers are concerned, which we are now adjudicating before this honorable court, there is no central legislation's requirement of TET. TET was introduced by the state of Assam in 2018 and 12. In 2018, 2018, I'll just place that rule. To improve the quality of the teachers in Assam, Assam secondary education provincialized within bracket rules 2018. It is in the manual, education manual. If Lordship is having this. And I can find that binding for Riva. It will be page 30 if I'm not wrong, if we are having the same. Page 30. Yes. Academic and professional qualification, Rule 10. The academic and professional qualifications for direct recruitment shall be as per Schedule 3. In addition, this is 2. In addition to such academic and professional qualifications mentioned in Schedule 3, the direct recruitment to the post, candidates shall have to appear and pass in the TET in the concerned cadre conducted by the government, scoring a minimum of 60% in case of unreserved category and minimum of 55% in case of scheduled caste, scheduled tribe, other backward classes and persons. So this was inserted in 2018. So we introduced the concept of an additional test apart from the professional and academic qualification in the act, in the rules, by introducing TET. And all the writ petitioners, if I'm not wrong, are TET qualified teachers, the qualified candidates. At that point of time, there was some challenges, but all those writ petitions, if I'm not wrong, Lordship, were withdrawn. The Honorable Court did not finally adjudicate these matters. This introduction of
Challenge to this
initially
of TET.
TET initially, but at one point they have all withdrawn and everybody participated. Now, in the second writ petition, Lordship will find that National Council of Teachers Education notification, 12 November 2014. Second writ petition, because I want to show this NCT's notification. Because they are basically harping that we are violating this. In the second writ petition, there is slightly different challenge, which I will address little bit later, Lord.
NCT notification.
Yes, page 56.
Yes.
Notification 12 November, in exercise of the power conferred under clause DD of subsection 2 of section 32, read with section 12A of the National Council of Teachers Education Act 1993, and in supersession of the National Council of Teachers Education, determination of Lordship will kindly mark this word, minimum qualification for recruitment of teachers in schools, regulation 2001, except as respects things done or omitted to be done before such supersession, the council hereby makes the following regulations. The regulations is given there. Now next page, the first schedule.
Yes.
First schedule under sub-regulation 2 of regulation 4. Regulation 4 is number 1, that qualification for recruitment above in the second paragraph, Lordship, of page 57. The qualification for recruitment of teachers in any recognized schools imparting pre-primary, primary, upper primary, secondary, secondary, intermediate, or colleges imparting secondary education shall be given in the first and second schedule as annexed to this regulation. So that is why I'm coming to first schedule. First schedule says the National Council of Teachers Education determination of minimum qualification of persons to be recruited as education teachers in pre-primary, primary, upper primary, secondary, senior secondary, or intermediate or colleges regulations 2014. Now, on left-hand side, it is level. Right-hand side, Lordship will again mark this word, minimum academic and professional qualification. Everywhere they are saying the minimum qualification. They are not prescribing maximum or the standard. So this minimum is the minimum qualification which the central government has prescribed, and state government must adhere to the minimum qualification, but they can always improve. That will be my case. So Roman, that's serial number 4. 4, no? For class 9, 10, graduate/postgraduate from recognized university with at least, Lordship will again mark this word, at least 50% marks in either graduation or post-graduation or its equivalent, and bachelors of education from National Council of Teachers Education recognized institution.
Yes.
So everywhere it is said that at least 50% should be there, and the prescription regarding the professional and academic qualification, it is the minimum that has been prescribed.
So your basic argument is that it is the minimum qualification and
we can always enhance, improve.
The state has to abide by that, but apart from that, they can also introduce a higher qualification.
Higher qualification, additional test, supplementary qualification.
But not less than the minimum qualification.
We cannot dilute it. That is our case. We cannot go beyond this. Whatever has been prescribed, because the whole intention of the central government is to have a uniform standard of teachers all across the country. That standard must be maintained. We cannot go beyond that standard. If we can upgrade our standard,
That's it. Have it with it. Is that higher quality? Minimum. That's it. Details of amount to
Yes.
so the NCT has prescribed the minimum academic and professional qualification. Now, whether we can go beyond that to upgrade?
Law on that.
Yes, law. Just, I have all the laws, Lordship, only 2 paragraphs from the 2 affidavits, because all the judgments will cover this situation only. Because what is the rationale of going for this upgradation? If Lordship is pleased to take. Paragraph 10 in Moni Gogoi's case 1414. So in paragraph 3, we have stated that for secondary education, that is not mandatory under the NCT, but for primary, it is mandatory. What I am trying to emphasize here is paragraph 10, small paragraph, but in the other case, the paragraph is a little bit longer. Paragraph 10, with regard to the contents in paragraph so and so, it is humbly stated that a conscious decision has been adopted by introducing that come recruitment test by taking into consideration several relevant factors, including the aspect that education in the present times is not restricted to imparting only knowledge involved in the course curriculum, but also have Lordship got. I'm reading it once more. It is humbly stated that a conscious decision has been adopted by introducing the TAP-CUM recruitment test by taking into consideration several relevant factors, including the aspect that education in the present time is not restricted to imparting only knowledge involved in the course curriculum, but also requires a teacher or educator to be in knowledge and aware of all the state of the art technologies and development. The TAP-CUM recruitment test would enable the state employers to assess the best performance of aspirants during each recruitment process. And as such, adoption of the recruitment test are in fact the norms of the day. Candidates like petitioners who claim to have qualified the TET qualification in 2020 are put to an advantage when they would be allotted additional marks based on their performance during the state TET examination of 2020. Pausing here for a moment, Lordship. What we are trying to do, the last TET for the graduates was held in 2020 and for postgraduate in 2021. Thereafter, there was no TET examination. In the meantime, there are 2-3 batches of students who have acquired the other academic and professional qualifications. If we have to start a recruitment process today on the basis of TET examination of 2020 or prior to that, in terms of 2018's rules, then 3 years, 3 batches will not get the benefit of participating in this recruitment process. So we have to hold a TET first in 2024, then going for a separate recruitment process for the entrance, for the recruitment. What we are doing earlier to this, Lordship, in elementary till now, we are only following the marks they have obtained in their various professional qualifications as well as academic qualifications, but as well as the marks obtained in TET. There is no written test. In secondary education also, that was the system. Lot of cases came up before this honorable court, and we made a commitment before this honorable court that we are either going to withdraw that completely and hold only recruitment test, or else we'll have recruitment test along with the TET. That was my submission to this honorable court. Those cases were closed accordingly. Now, what we are doing, Lordship, that we are not abandoning that in toto. What we are doing, we will keep that as well as the written test, and we have combined it. So that all the students who have acquired the educational qualification plus professional qualification in 2024 July, they are also eligible to participate in this recruitment process, because that is also going to be held together with the recruitment test. And at the same time,
coupled both the things.
We have combined, amalgamated. Apart from that, they have acquired TET in 2020.
They'll get additional 5% mark.
That benefit they will get. In top of that, we have to think it from the perspective of the students. Whether these batches or those who have acquired in 2016, they are still updated themselves with the present day situation, because from 2018 to 2024, there's a paradigm shift in the education system with the introduction of online coaching and etc. during the COVID. Earlier, there was no such thing. So we want to embrace all of them and put them in a level playing field, keeping in interest of the students. Ultimately, we are always focusing on the student-centric system. Engineering 2004. Constitution or 20. Or 25. Please do it.
Yeah.
Lordship. Next paragraph, paragraph 11, because we have to be clear what exactly is their case also. Paragraph 11, the assertions made by the petitioner in paragraph 22 and 23 of the writ petition are apparently preposterous, since the petitioner asserts that they have a vested right for appointment only because they were eligible under the erstwhile unamended rules, that is 2018 rules, which also prescribes TET. It is their own assertions of the petition that they could not qualify in the earlier round of recruitment process due to their low merit. The assertions of the petitioner that they ought to be appointed on the basis of their performance in the earlier TET examination is wholly fallacious and in fact would act against their own interest. So now pausing here for a moment, Lordship. On one hand, they are saying that is not prescribed by NCT. You cannot do it because that is repugnant to the central legislation. On the other hand,
That point we have already pointed out to.
that is why I am little bit confused, Lordship, still, whether, suppose Lordship set aside the TET come recruitment. Let us assume that, Lordship. What will be the situation? Their TET marks will still be there and they will take one recruitment on the basis of their TET qualification. You cannot have both the cake and eat it too, Lordship. So they have to make their stand clear before challenging a statute. They have to be very firm on their position. They cannot change positions according to their arguments. So we have to argue on the basis of the pleadings. Therefore, we are still confused whether they want TET or they do not want TET.
They want earlier TET and no.
Earlier TET is not in conflict with the central legislation. The subsequent TET is in conflict with the central legislation. If that be the argument, I have nothing to say except giving a smile before this honorable court. So now, this is the first ground. First, the other writ petition, they says that what we are prescribing, that they have to have postgraduate degree and at their graduate level, they must have the same subject in which they are having the post-graduation so that they will be recruited. Suppose they are having post-graduation in English. In English, example, I'm exempt.
Yeah.
So we want their graduation also in English. Also in English. The reason is we have explained in paragraph 9 of the other affidavit, Lordship. Then I'll go to the legal submissions as well as the judgments, which will be common for both the cases. Even affidavit, yeah? The other affidavit. The other affidavit in Dhruvajuti Nath and others. Why we have done it, Lordship? Paragraph 9. It will be a little bit long, but there are reasons and the logic here.
Just Yes.
Yes, Lordship. It is humbly stated, paragraph 9, Lordship. It is humbly stated that, paragraph 9. Down below, Lordship. In page 62, if I'm not wrong.
Yeah, it is only.
It is humbly stated that NCT has strived to achieve planned and coordinated development of the teachers' education system throughout the country by laying down the minimum norms of eligibility, and it has not, as it cannot lay down the recruitment criteria for appointment of teachers. It is a settled position in law that a requirement higher than the minimum prescribed eligibility condition can be laid down for recruitment to public post. Though prior to amendment of 2023, postgraduate teachers were appointed without requiring them to have read the same subject in PG course as one of the subjects in graduate level, as it was realized that such recruitment posed several difficulties in the teachers discharging efficient instructions to the students. The minimum educational qualification required for teaching in high school section is graduate degree along with B.Ed. It is also mandatory for the postgraduate teachers to teach in the high school section of the higher secondary schools. The syllabus for master's degree is steered towards higher order thinking and is research oriented. Basic concept of the subject are given at bachelor degree program. To deal with the school syllabus and textbook, teachers must have conceptual clarity of the subject concerned because of the requirement to link students' learning with critical thinking, creativity, and real-life situations. Since learning at the school level occurs in the sequential and graded manner, it has been noticed practically that a person with master degree in a subject which was not a subject pursued at the bachelor degree is often deficient in basic concepts that are inevitable for teaching at school level, especially in case of competency-based education. It is relevant to note here that there is no bar of subjects to be undertaken in graduation level for obtaining admission to a postgraduate course. For example, a student to pursue bachelor's degree in science after having studied in English medium school can pursue his master degree in Assamese. However, it has been noticed that due to lack of basic knowledge in Assamese, she cannot impart proper teaching to the students of the high or higher secondary school in Assamese once he is recruited as a postgraduate Assamese teacher. Basic and thorough knowledge of subject is a must for teachers of secondary education. Secondary education prepares students for life. They offer more specific skills, training, critical thinking, and application of learning in various situations. Students gain more independence and the right to make more choices of their own. The secondary stage is a fundamental/crucial stage where the teacher shares her knowledge that she acquired from the age of primary stage to the stage acquiring masters. A notable disadvantage of not having the same subject in graduation and post-graduation is the possibility of a fragmented educational experience. Overall, a lack of coherence between the two educational levels may hinder the seamless development of expertise in a specific field. It is relevant to note some more advantages of recruiting postgraduate teachers who have the same subjects in their graduation. One is depth of knowledge. Teachers with a background in the subject they teach at higher level often have a deeper understanding of the concepts. This can lead to a more comprehensive and insightful teaching approach. Specialized skill. A teacher who has studied a subject extensively is likely to have developed specialized skill and technique that can benefit students. Passion and interest. Teachers who have studied a subject they are passionate about are more likely to inspire students and create a positive learning environment. Effective communication. Teachers who are well versed in a subject are usually better at explaining complex concepts in a way that is easy for students to understand. Curriculum development.
So that you have differentiate, this is an intentional differential.
Yes.
Which you have highlight.
Lordship. So as an employer, I'm sorry.
From where you will see this analogy, this what you are justifying, from where you got it?
So in our, we have expert bodies and we have discussions on this.
When?
Before,
Where were those deliberations?
yes, Lordship.
And the person who has filed this affidavit, he has not said anything about this para 9. It is nothing. It is simply, as brother has pointed out, see the affidavit. The statement made in affidavit, in this affidavit is 1 to 8, 10 are true to my knowledge. Brother has rightly pointed out.
Fine.
Where you got this is the idea.
That is why a astute lawyer should not go to the other side.
Hmm?
A astute lawyer should not go to the other side. We always find it.
That is for my advantage and for your disadvantage, I can't help.
No, Lord. But what he has written, it may be a technical error.
Sir, it doesn't amount to this specifying a qualification which is not there in the NCT guidelines. That NCT guidelines.
NCT guidelines, whether, yes,
Graduate and postgraduate.
yes, Lordship.
You are adding another qualification that the person who is getting
As employer, don't we have a right to specify the subject?
not contrary to the NCT guidelines.
What NCT is saying?
NCT is saying postgraduate, graduate. and
We are
postgraduate.
still
They are not
saying,
restricting.
no.
They are not
I leave it to learn, but I have not make my full arguments. Now, NCT has, what NCT has said? NCT has said that you must have graduate, you must have postgraduate.
But there is no further distinction or classification.
NCT has not prescribed these qualifications for a particular subject teacher. From the employer's point of view, they have not indicated anything, Lordship. When we want a teacher to teach a particular subject,
Yes.
we have the right to say that what are the qualifications. That is not the domain of the NCT. What NCT is saying that pan India, there should be a proper standard. A teacher who is going to teach the secondary level education must have a post-graduation degree with minimum at least 50%. That are we diluting? We are making it not 40%. NCT, suppose it's now, Lordship, we want a physics teacher. NCT is not saying any subject. Because in the postgraduate level also, can a chemistry teacher, chemistry qualified postgraduate candidate can come and join physics? NCT has not gone into that domain. Lordship, I am having a postgraduate degree in Sanskrit. And there is a recruitment of physics professor. Can I apply? Because I am also having a postgraduate degree.
Postgraduate means postgraduate.
Postgraduate means postgraduate.
Yeah.
So
In
from
any
that
stream,
point,
any subject.
that means that will open a floodgate. Suppose a chemistry teacher is required. And for that,
I mean the floodgate, postgraduate, only the postgraduate can apply for that.
postgraduate in other subjects,
They can only apply.
where is that in NCT, Lordship? That is not there in the NCT. NCT is not talking about any subject.
That is that is to be not to be defined in so many words. So that is there. Sir, you just see you can do one thing. You could have done one thing. Postgraduate at least this 50% mark. You can enhance it up to, as per your argument, that you can prescribe a
Here also,
higher
Lordship.
qualification than the minimum qualification. You can prescribe it up to 60%, 70%, 80%. We would have understood, sir.
That is one view, Lordship. Otherwise, Lordship, suppose there is a requirement of English teacher. A person having postgraduate degree and graduate degree can apply. Can a person having postgraduate degree in Hindi also apply? And are you going to take him? Because if we look at the first schedule,
इजी तो 55% को फिनिश कर रहे
Two, three recruitments we have done.
Yes.
Yes, this is because of our experience.
Schedule 1, Schedule 3, clause 1 in trade.
We allowed earlier.
Even
We earlier, because we had, why I'm telling this,
Did you appoint us? Is it the master degree holder in chemistry to a post in given? Did you appoint?
we have not, but there are certain situations, I'm telling, submitting this, we faced this problem in Barak Valley. Huge number. We wanted a particular subjects teacher. All other participated and they got it. When they went to that school to give the education, it was totally a mess.
That is something to do with litigation.
That is why we have corrected the law. We have,
You have corrected the law to the extent that you have not been corrected the law till
Exactly.
you have not said that the post-graduation qualification must be for the subject. You have not said.
what we have,
Say that post-graduate in physics must also have in graduation. This- that much will be-
because the corrigendum, they have not annexed in the recruitment because there is a corrigendum also to the advertisement. Right, na?
पानी आने वाली है हमने बहुत पानी को पहला पूरा
During the advertisement, the candidate shall apply in the particular subject in case of post-graduation.
जो देखा क्या होगा Yes.
So if we look at the NCT regulation, notification of 12th November, Lordship, page 56. If you look at Schedule 1, serial number 4, graduates, postgraduate from recognized university with at least 50% in the either graduation or post-graduation or equivalent and Bachelor of Education BEd from National Council of Teachers Education recognized institution. So there is no reference to any subject here. This is a general one. So this general, we cannot dilute. The thing is that when we need a particular subject teacher, so we have to prescribe it in that line only. Therefore, we have to read this with one of the clause of the advertisement at page 43.
Suppose if you, you are a wing post, suppose this teacher physics.
Lordship.
This is the, you have advertisement, that is advertised this.
Yes.
What is the qualification for physics, teacher physics in the, this, recruitment rules?
Sorry, Lord.
What is the qualification prescribed for this?
The rules does not have subject-wise provisions. It's a general provisions, Lordship. We cannot have, suppose subjects, tomorrow it may change, tomorrow some subjects may go, new subjects may, every year we do not amend the rules, Lordship. The rules are general. The additional conditions have to be given in the advertisement. Whatever we have put in our advertisement are not, we do not find every terms and conditions of
Yes.
And there is a further, because if Lordship is pleased to come to page,
Mean to say that
page 43.
for the purpose of this, teacher, for the 9th and 10th standard, this 9th and 10th standard, there is a graduate or postgraduate or recognized university, you have not disturbed that.
We have not disturbed that.
Now, in respect of senior secondary, this intermediate 10th and 11th and 12th. Here you have prescribed postgraduate with at least 50% or equivalent from recognized university and Bachelor of Education, B.Ed from the National Council of so and so.
Yeah.
Here you additionally prescribe that a postgraduate, Bachelor in Education, a person of having postgraduate should also have the same subject in the graduation.
Yes.
This is what you have.
Yes.
From there, this NCT has not provided.
NCT has not provided whether we can provide that or not.
That is,
That is right. Yes.
that prima facie.
If we go, because we have to see it from a rational point of view with some logic. What NCT is providing us, that to have a postgraduate level teacher, the educational qualification, they must have B.Ed, etc., professional qualification plus postgraduate degree. What we are saying, they have not said in which subject. If we accept their argument, Lordship, then any person having a postgraduate degree or a graduate degree can apply for any subject. This is their argument.
This is what your minimum qualification is.
Minimum qualification.
Minimum educational.
Minimum qualification has to be read.
Post of postgraduate teacher.
Yes, postgraduate teacher, and postgraduate teacher can be of several subjects. We are not on that. What we are on that, for any postgraduate teacher for a particular X subject, what we are saying that you must have that subject's post-graduation degree as well as that subject's graduation degree. Otherwise, it will not be workable at all. Not only in Assam, anywhere in the country. One more thing to listen to.
Postgraduate in science can apply for the post.
There will be no postgraduate in science. There will be a particular subject in postgraduate science. It can be botany, it can be geology, it can be chemistry, physics, anywhere. It cannot be in science. In graduation level, it can be science, Lordship, BSc.
Have you prescribed that how many posts in the, suppose in a postgraduate?
Yes, that is what they have not submitted the addendum. Yesterday, we had another case where in botany, what we have, our expert committee said MSc in botany or MSc in biotechnology. Some other persons, they had microbiology. So they wanted, today their case came in favor of the state government, Lordship. Today their judgment. Here, this addendum, we have, suppose, we have, actually, let me replace it. Lordship will know how many posts and how many subjects. That is why I'm taking Lordship to page 43. Page 43, Lordship will kindly.
See, Miller, page 43.
Page 43, kindly see.
Page
43, C.
Page 43. Two, criteria for selection of postgraduate teachers. Here, Roman O. Page 43, Lordship.
First or secondary?
It is in Lordship. It is in
WPC 1.
Rubojutinath.
Rubojutinath.
Rubojutinath. During, I'm sorry.
Yes.
During, have Lordship got it to Roman O. C. During the advertisement, candidates shall apply in the particular subject in case of postgraduate teachers. So this chart was also published. So suppose taking an example of history, there are three parts of history: ancient history, medieval history, and modern history. Suppose we wanted teachers in medieval history. So the other two categories of having postgraduate can also not apply. That is the mandate of the Supreme Court. Those judgments also I'm placing. Only having post-graduation degree will not suffice.
For example, you here in this addendum, you have simply history, MA in history,
Yes, I'm giving an example. In Supreme Court dealt with that kind of a case. Let me place that judgment for Lordship. Lordship.
That is not the situation.
Now, that is what I am trying to emphasize. Even in one subject, there are several parts. That can also be, that means what we are going for specialization nowadays. Earlier, MBBS doctor was doing everything. Now we have specialized and super specialized section. The whole education system is getting upgraded. Now, the simple MBBS is not eligible to do practice also in proper format. Government cannot take them. They must have postgraduate degree, MDS or MD. And beyond that also now, the this doctorate of science, the super specialization part where there is no reservations. Yes, we'll file and sort affidavit, Lordship.
Affidavit up, when we'll decide.
No, because this was to be given by the other side. They have given part. Luckily, I was arguing this case. That's why I came to know. So, in this advertisement,
Yes.
so in this advertisement itself, there's an indication that in which subject you are going to apply. That clearly indicates that if you have a particular degree in a particular subject, that advertisement or that corrigendum also clearly indicates. In addition, that is also not part of the, this is also not part of the statute. This is what the employer is exercising, Lordship, according to the need. And that is not been barred by NCT. We are not diluting. We are not saying that a postgraduate with less than 50% with a particular subject is allowed to participate in the recruitment process. No. Keeping the standards set by NCT, we are going for some specialized area. Whether that is permissible or not, whether that is in conflict or there is some repugnancy. The law in this case, line, Lordship, is well settled. From Preeti Srivastava's case, series of case thereafter, and one another case of 1986 also. But I would like to first place 2004, 4 SCC, page 513. State of Tamil Nadu and another verses, S.V. Brathev.
SCC, page?
Page 513, 13. Paragraph 5.
Yes.
We shall now examine only the question posed before us as to whether the norms prescribed by the state government are contradictory to the norms fixed by AICT or are only in the nature of higher qualification above the minimum prescribed by AICT for admission to the engineering colleges. AICT prescribed in their guidelines for the relevant period as follows. Qualification for admission of general students. The minimum qualification for admission to degree programs in engineering should be a pass in 10+2 senior secondary examination with a minimum aggregate of 60% in physics, chemistry, mathematics obtained in a single sitting. So this is the prescription. The duration of degree program in engineering will be 4 years after 12th standard. This will apply to cases where admissions are based on the marks in the qualifying examination and not on the basis of entrance. What I am trying to highlight here is that, Lordship, here the AICT also prescribed the subjects. The NCT did not prescribe the subjects. 60% and single sitting. That means there are no betterment candidates can participate. Now coming to 8, High Court rejected what High Court found. 6, while the government provided the basic qualification for eligibility is as adverted to us by earlier. The High Court found that there are two streams of admission of students as prescribed by AICT, namely those who are admitted on the basis of marks secured in the qualifying examination only, and those who are admitted on the basis of the marks secured in the common examination test held by the state or the union territory. The High Court is of the view that AICT has contemplated two categories of students seeking for admission as noted above by us, and there is no other category of students contemplated by AICT who are aspiring to apply for engineering seat. Therefore, the norms fixed by the state are in stark contradiction to the norms fixed by AICT. To arrive at this conclusion, the High Court very strongly relied on the decision of the state of Tamil Nadu versus Adhiniyam Education and Research Institute. 8. As regard to the scope of the entries in the Constitution arising under entry 66 list 1 and entry 25 of list 3 of the 7th schedule to the Constitution, it was examined in great detail by a Constitution bench of this court in Priti Srivastava versus State of Madhya Pradesh. I'll place this judgment also. After adverting to these two entries in the 2nd schedule, this court stated as follows. Both the union as well as the state have the power to legislate on education. Ours is the case on education here, including medical education subject inter alia to entry 66 of list 1, which deals with laying down standards in institutions for higher education or research and science and technical institutions, as also coordination of such standards. A state has therefore the right to control education, including medical education, so long as the field is not occupied by the union legislation. Secondly, the state cannot, while controlling education in the state, impinge on standards in institutions for higher education, because this is exclusively within the purview of union government. Therefore, while prescribing the criteria for admission to the institution for higher education, including higher medical education, the state cannot adversely affect the standard laid down by the union under entry 66 of list 1. Secondly, while considering the cases on the subject, it is also necessary to remember that from 1977, education, including inter alia medical and university education, is now in the concurrent list so that the union can legislate on admission criteria also. If it does so, the state will not be able to legislate in this field except as provided by Article 254. It would not be correct to say that the norms for admission have no connection with the standard of education, or that the rules for admission are covered only by entry 25 of list 3. Norms of admission can have a direct impact on the education of a standard of education. Of course, there can be rules for admission which are consistent with or do not affect adversely the standard of education prescribed by the union in exercise of the power under entry 66 of list 1. For example, a state may, for admission to the postgraduate medical courses, lay down qualification in addition to those prescribed under entry 66 of list 1. This would be consistent with promoting higher education for admission to the higher educational courses, but by lowering the norms laid down can and does not have an adverse effect to the standards of education in the institutes of higher education. Entry 25 of list 3 and entry 66 of list 1 have to be read together, and it cannot be read in such a manner as to form an exclusivity in the matter of admission. But if certain prescriptions for standard have been pursuant to entry 66 of list 1, then those standards will prevail over the standards fixed by the state in exercise of power under entry 25 list 1, insofar as they do not adversely affect the standards laid down by the Union of India or by any authority functioning under it. Therefore, what is to be seen in the present case is whether the prescription of standards made by the state government is in any way adverse to or lower than the standards fixed by the AICT. It is no doubt true that AICT prescribed two modes of admission. One is merely dependent on the qualifying examination and the other dependent on the marks obtained in the common entrance test. The appellant in the present case prescribed the qualification of having secured certain percentage of marks in the related subject, which is higher than the minimum in the qualifying examination in order to be eligible for admission. If higher minimum is prescribed by the state government than what had been prescribed by AICT, it can be said that it is in any manner adverse to the standards fixed by AICT or reduces the standard fixed by it. In our opinion, it does not. On the other hand, we proceed on the basis that the norms fixed by AICT would allow admission only on the basis of the marks obtained in the qualifying examination. The additional test, Lordship will kindly mark here, we have the TET. The additional test made applicable in the common test by the state government. If we proceed to take the standard fixed by AICT to be the common entrance test, then the prescription made by the state government of having obtained certain marks higher than the minimum in the qualifying examination in order to be eligible to participate in the common entrance test is in addition to the common entrance test. In either event, the stream proposed by AICT are not belittled in any manner. The manner in which the High Court has proceeded is that what has been prescribed by AICT is inexplorable, and that the minimum alone should be taken into consideration, and no other standard could be fixed, even the higher, as stated by this court in Priti Srivastava case. It is no doubt true, as noticed by this court in Adhiniyam case, that there may be situations when a large number of seats may fall vacant on the account of higher standards fixed. The standard fixed should always be realistic, which are attainable and are within the reach of the candidates. It cannot be said that the prescriptions by the state government, in addition to those by AICT in the present case, are such which are not attainable or which are not within the reach of the candidates who seek admission for engineering colleges. It is not a very high percentage of mark that has been prescribed as minimum of 60% downwards, but definitely higher than the mere pass mark. Excellence in higher education is always insisted upon by a series of decisions of this court, including Dr. Priti Srivastava's case. If the higher minimum marks have been prescribed, it would certainly add to the excellence in the matter of admission of the students in higher education. Then Lordship will kindly come to paragraph 12. Another argument is further advanced before us that the criteria fixed by AICT were to be adopted by the respective colleges, and once such prescriptions has been made, it was not open for the government to prescribe further standards, particularly when they had established the institution in exercise of their fundamental rights guaranteed under Article 19 of the Constitution. However, we do not think this argument can be sustained in any manner. Prescription of standards in education is always accepted to be an appropriate exercise of power by the bodies recognizing the college or granting affiliation like AICT or university. If in exercise of such power the prescription has been made, it cannot be said that the whole matter has been foreclosed. In this view of the matter, we think these appeals deserve to be allowed in part, and the order of the High Court stands modified to the extent stating that it is permissible for the state government to prescribe higher qualifications for purposes of admission to the engineering colleges than what has been prescribed by AICT, and what has been prescribed by the state and considered by us is not contrary to the same, but is only complementary or supplementary to it. It is made clear that if any madness, so in the present case also, pausing here for a moment, what we are giving is an additional thing. Here also the state government has prescribed another test apart from the common test. That is also allowed. One argument may come from the other side now. Clean school. Education including technical. 20%. In addition to coming to the next judgment, Lordship, P.T. Srivastava. Dr. P.T. Srivastava and another versus State of MP and batches of cases were dealt with by the Constitution Bench comprising of 5 judges, delivered this judgment, reported in 1999, 7 SCC, page 120.
Yes.
So it is a constitutional judges bench, Lordship. Paragraph, lot of paragraphs are important. I'll just take your Lordship to 3-4 paragraphs.
Yes.
Paragraph 35 at page 153.
Yes.
The legislative competence of Parliament and the legislatures of the state to make laws under Article 246 is regulated by 7th schedule to the Constitution. In the 7th schedule, as originally in force, entry 11 of list 2 gave to the state an exclusive power to legislate on education, including universities, subject to the provisions of entry 63, 64, 65, 66 of list 1 and entry 25 of list 3. Entry 11 of list 2 was deleted and entry 25 of list 3 was amended with effect from 3/1/1976 as a result of Constitution's 42nd Amendment of 1976. The present entry 25 in the concurrent list is as follows. Entry 25, education including technical education, medical education and universities subject to the provisions of entry 63, 64, 65, 66 of list 1, vocational and technical training of labor. Entry 25 is subject to inter alia to entry 66 of list 1. Entry 66 of list 1 is as follows: coordination and determination of standards in institutions for higher education, research, scientific and technical. So ours is not higher education here. So basically this will not come, but still
Yes, sir.
both the union as well as the state have the power to legislate on education, including medical education, subject inter alia to entry 66 of list 1, which, no, Lordship, I'm hearing something. That's why I am stopping.
Hearing.
Anyway, Lordship, which including medical education, subject inter alia to entry 66 of list, which deals with laying down standards in institutions for higher education or research, and scientific and technical education institutions as also coordination sub standards. A state has therefore the right to control education, including medical education, so long as the field is not occupied by any union legislation. Secondly, the state cannot, while controlling education in the state, impinge on standards in education institutions in higher education, because this is exclusively within the purview of the union government. Therefore, while prescribing the criteria for admission to the institutions for higher education, including higher medical education, the state cannot adversely affect the standards laid down by the Union of India under entry 66 list 1. Secondly, considering the cases on the subject, it is very necessary to remember that from 1977, education, including inter alia medical and university education, is now in the concurrent list, so that the union can legislate on admission criteria also. If it does so, state will not be able to legislate in this field except provided in Article 254. It would not be correct to say that the norms of admission have no connection with the standard of education, or that the rules of admissions are covered only by entry 25 of list 3. Norms of admission can have a direct impact on the standard of education. Of course, there can be rules for admission which are consistent with or do not affect adversely the standards of education prescribed by the union in exercise of power under entry 66 of list 1. For example, a state may, for admission to the postgraduate medical courses, lay down qualification in addition to those prescribed under entry 66 of list 1. This would be consistent with promoting higher standards for admission to the higher educational courses. But any lowering of the norms laid down can and does have an adverse effect on the standard of education in the institution of higher education. Standard of education in an institution or college depend upon various factors. Some of these are caliber of the teaching staff. First one is very Yes. Last line of paragraph 36, standard of education in an institution or college depends upon various factors. Some of these are: one, the caliber of the teaching staff. I'm only highlighting this. Now coming to paragraph 37. While considering the standard of education in any college or institution, the caliber of the students who are admitted to that institutions or college cannot be ignored. Replacing the word students as teachers here. We will follow the same principle, Lordship. While considering the standard of education in any college or institution, the caliber of the students or vis-a-vis, Lordship, the teachers who are admitted to that institution or college cannot be ignored. If the students are of high caliber, training programs can be suitably molded so that they can receive the maximum benefit out of a high level of teaching. If the caliber of the students is poor or they are unable to follow the instructions being imparted, the standard of teaching necessarily have to be lowered to make them understand the course which have been undertaken. It may not be possible to reach the level of education and training which can be attained with a bright group. Now coming to the last paragraph. This court therefore upheld that additional criteria framed by the state for admission, which were not inconsistent with the norms of admission laid down by the University Act. Since these additional qualifications did not diminish the eligibility norms under the University Act, this court upheld the additional criteria laid down by the state as not affecting the standard laid down by the University Act. The question of diluting the standard laid down did not arise. So we are not diluting any of the conditions of NCT. In whatever is there, we are keeping it intact and we are giving some additional qualification, just like adding the TET or a specific subject of post-graduation. We are not saying that graduate with a particular subject can be allowed to work as a postgraduate teacher. No, we have not diluted. We have not brought down the minimum eligibility criteria regarding the qualification part. Going further, this paragraph will clarify everything. 39. The respondents have emphasized the observations that admission has to be made by those who are in control of the colleges. But the question is on what basis? Admission must be made on a basis which is consistent with the standard laid down by a statute or regulation framed by the central government in exercise of its power under entry 66 list 1. At times, in some of the judgments, the word eligibility and qualification have been used interchangeably, and in some cases, a distinction has been made between the two words. Eligibility connoting the minimum criteria for selection that may be laid down by the University Act or the central statute, while qualification connoting the additional norms laid down by the college or by the state. In every case, the minimum standard as laid down by the central statute or under it have to be complied with by the state while making admission. It may, in addition, lay down other additional norms for admission or regulate the admission in exercise of its power under entry 25, list 3, in a manner not inconsistent with or in a manner which does not dilute the criteria laid down.
Yes.
paragraph 41, there is a judgment of Andhra Pradesh, and paragraph 42, the findings. Therefore, this court considered the entrance test held by the state in that case as not violating entry 66 of list 1 because the statutory provisions of Andhra Pradesh University Act were also complied with and the test was not inconsistent with those provisions. Secondly, in that case, the court viewed that the test was not in substitution of HSC, PUC, ISC or other such examination, but in addition to it. So that is an addition to the other qualifications, academic or professional qualification, for the purpose of proper selection from out of a large number of students who had applied.
Yes.
Paragraph 57.
Yes.
Basically, the same thing is being repeated, Lordship. So my humble submission on the basis of this case is that as we have not diluted or not given up the criteria of minimum qualification under the NCTE, Lordship, there is absolutely no violation whatsoever and there is no repugnancy also.
Yes.
On the basis of these two judgments, Lordship, and few others, the Honorable Division Bench of this Honorable Court, in the case of Siddharth Sarkar versus State of Assam, reported in 2007, Volume 3 GLT, page 715.
Yes.
The Division Bench was also pleased to hold that it is permissible. Here, the state, the 2007, 3 GLT, page 715. The then Chief Justice, my Lord Justice Chalamester and my Lord Justice H. Roy delivered this judgment. It was decided on 24th May 2007. It was tested several times later on before this division bench. I think my Lord Justice Nair also argued against us in the, not in this case, but subsequent cases. But this judgment is still remaining intact. Paragraph. Here the relevant paragraph will be paragraph 20 onwards. In our opinion, here the state government enhanced the qualification, a minimum qualification.
They relied upon this Preeti Srivastava and all.
Yes, Lordship.
And these Supreme Court judgments are there.
Because that is why I am having the JNK judgment also. I am not suing. This is the division bench of this honorable court. The coordinate bench of this.
Same proposition of law.
Same proposition. It is permitted. We have enhanced from 50% to 60%. And there should not be any betterment candidate. That was not prescribed by MCI at that point of time. We said that no betterment candidate in single sitting, just like the engineering streams.
Fine.
So that was introduced in Assam. It was not there. So no candidates who got improvement of their marks in a subsequent examination, they are not allowed in physics, chemistry, and biology. And also from 50% minimum qualification, we enhance it to 60%. So this honorable court upheld our decision. So the state has the power. And on top of that, all these judgments, which I am showing, are in respect of the higher education. When it is higher education, 25 is also subject to the provisions of entry 66 of list 1. In list 3 item, this entries 25, we have a better, in a much better position because we are not in the vocational education or higher education or technical education. If Lordship is pleased to see entry 66 of list 1, it says, sorry, 25, entry 25 of list 3, education including technical education, medical education, and universities subject to provisions of 63, 64, 65, and 66 of list 1. What is 63? 63 is institution of list 1. I am coming, Lordship. Institution known as the commencement of this constitution as the Banaras Hindu University, Aligarh University. So that is not applicable. 64, institution of scientific or technical education financed by the government of India. Again, we are not on that. 65, union agencies and institutions for professional, vocational, technical training to promotion of special studies, C, scientific and technical. And 66, coordination and determination of standard of institutions for higher education or research and scientific and technical education. So all these areas we are not touching by exercising the power which flows from NT 25. It is a general education at the level of elementary as well as secondary. So now one argument from the other side that may come up, Lordship, that all my judgments are relating to admission to the medical college and engineering colleges. We are exercising and we are legislating in the field which is covered by entry 25 of list 3.
Yes.
So we are legislating because they are challenging our two provisions of the rules. From the entry at 25, item number 25 of list 3, which is education. And education covers both admission as well as recruitment of teachers. Standard of education. So the principles which are governing the field of admission in educational institution, identically, Lordship, my submission would be the same principles is also applicable for recruitment of teachers in educational institutions. So though the education covers both teachers as well as the students.
Yes.
On the point of Article 254(2), if we have legislate on any provisions of law by which either we dilute or go against, or it is in conflict, then Article 254 will come into play. Here we are sailing, and this particular argument, my argument, Lordship, I'm taking recourse to all the judgments of the Honorable Supreme Court. The Honorable Supreme Court has very categorically in so many judgments have said that we can always improve the conditions or add to the conditions or supplement or give complement to the conditions laid by the central legislation. Here, the central legislation is using the term very prudently, or maybe after due application of mine, they are using the word minimum qualification. Not, it is not the standard qualification, minimum standard qualification. Had the minimum word is not there, then we would have understood it that we have to follow in ditto whatever is there in the provisions of NCT. But as because the prescription starts with the word minimum qualification, minimum academic qualification, minimum professional qualification, so we can always upgrade ourselves. So when we say that the subject in which a particular teacher has to be admitted, we want that particular subject's student or candidate who can come for the participation in the recruitment process. Otherwise, it will not be a workable situation. A Sanskrit teacher we want, a French teacher will come and apply, French candidate, having French qualification. How will it work? The system will collapse. It will be totally non-workable situation. That is why the NCT has also said graduation 50%, post-graduation 50%, but there is no indication, no prescription regarding the subjects. That area is left to the employer. I know that I need a driver who can drive a motorcycle or a car. If I have to have a driver to operate a highly inflammable vehicle like petroleum carrying vehicle, I will have a different criteria. Everybody has a license. The other day, the Supreme Court also on LMV given a very wider meaning that LMV includes any vehicle up to 7,500 kgs. But there also the Honorable Supreme Court has laid down certain conditions. If a particular vehicle is within that limit also, if it needs an explosive license or something, then different kind of license will be required for the driver. I may have a postgraduate candidate, but in what subject and what will he teach? It is not for the candidate's qualification we are concerned. We want the particular student who is learning history. He should be taught by a person who is well qualified in the subject of history. A geography teacher or geography candidate having post-graduation or other PhD qualification also will not be qualified to teach a student who is learning the other subject, which the candidate is qualified. In that line, Lordship, I would like to place a judgment of the Supreme Court. Two 2022-12 SCC base 42. This is also the post of postgraduate trained teachers in High School of Jharkhand. Indresh Kumar Mishra and others versus State of Jharkhand. Not a very old judgment. My Lord Justice Amar Shah and My Lord Justice Nagrathnath judgment. Here, paragraph 6.1. 4 paragraphs, small sub-paragraphs. At the outset, it is required to be noted that the present appeals, the dispute is with respect to the post, namely postgraduate trained teachers in history and graduate trained teachers in history civics. As per the state, so far as the GTT is concerned, the requirement was a combination of history/civics. As per the advertisement, a candidate must have the postgraduate bachelor's degree in the subject of history. So far as the GTT is concerned, the educational qualification required was bachelor's degree in history as well as political science as required and was for history civics. Therefore, for both the post, namely the postgraduate trained teachers history and graduate trained teachers history/civics, a candidate must have postgraduate degree in history as a whole. We have gone through the degree certificates in the case of the respective writ petitioners. It appears that the respective writ petitioners have obtained the postgraduate degree, bachelor's degree in case one in the branches of history, namely Indian ancient history, culture, medieval modern history, Indian so and so. In our view, obtaining the degree in one of the branches of history cannot be said to be obtaining the degree in history as a whole. As a history teacher, she has to teach in all the subjects of history, namely ancient history, Indian ancient history and culture, medieval/modern history, etc. So this is the facts. Now coming to paragraph 6.4. At this stage, it is required to be noted that even as the request of JSCC, the question whether
6.4 with para
6.5 is very important, Lordship.
6.5.
I am reading.
Supreme Today version.
I'm sorry, Lordship. I am reading from Supreme Today.
No, we have not been able to.
So I'm so sorry, Lordship. Actually, citation I gave.
From where you start?
I started paragraph 5. I started from paragraph 6 at the outset.
And the
Outset.
15.
Lordship, I'm so sorry. I never use this. I always use SSA. So, at the outset, it is required to be noted that the present appeals, the dispute is with respect to the post, namely postgraduate trained teachers in history and graduate trained teachers in history civics. As per the state, so far as the GTT is concerned, the requirement was a combination of history/civics. As per the advertisement, a candidate must have the postgraduate/bachelor's degree in subject history. So far as the GTT is concerned, the educational qualification required was bachelor degree in history as well as political science, as the requirement was for history/civics. Therefore, both the namely the postgraduate trained teachers history and graduate trained teachers history civics, a candidate must have postgraduate bachelor's degree in history as a whole. This was their submission. We have gone through the degrees/certificates in the case of the respective writ petitioners. It appears that the respective writ petitioners have obtained the PG degree, bachelor's degree as the case may be, in one of the branches of history, namely Indian ancient history, Indian ancient history and culture, medieval, modern history, so and so, so and so. These are different branches. In our opinion, obtaining the degree is in one of the branches of history cannot be said to be obtaining the degree in history as a whole. As a history teacher, she has to teach in all the subjects of history, namely ancient history, Indian ancient history, culture, medieval, modern history, Indian ancient history, culture, and archaeology, etc. Therefore, having studied and obtaining the degree in only one branch of history cannot be said to be having a degree in history subject as a whole, which was the requirement. All the relevant aspects have been considered and gone into in details by the learned single judge meticulously. I am coming to now paragraph 4. At this stage, it is required to be noted that even at the request of at this stage, have Lordship got it? It is required to be noted that even at the request of JSCC, the question whether the degree obtained by the respective petitioners in one branch of history can be said to be sufficient compliance as per the advertisement and can be said to be obtaining a degree in history came to be considered by the expert committee, and the expert committee has opined that the degree obtained by the respective candidates petitioners in one branch of history cannot be said to be obtaining the degree in history as a whole, and therefore they cannot be said to be having the requisite qualifications as per the advertisement. As per the settled proposition of law, now the law, in the field of education, the court of law cannot act as an expert normally. Therefore, whether or not a student candidate is possessing the requisite qualifications should better be left to the educational institutions, more particularly when the expert committee considers the matter. So, in the present case, the educational qualification required has been specifically mentioned in the advertisement. So, in our case, Lordship, the statute was done on the basis of the opinion given by the expert committee. Yesterday also, before learned single judge also, I have placed the minutes of the expert committee. When we said that for the purpose of having postgraduate teachers in botany, only 2 streams of that subjects are required, not the microbiology. The judgment came in our favor. It was delivered today. We'll get a copy, Lordship. So here also, Lordship, it is not for no reason that we have amended the rules. We do not have any blue-eyed person to help or to discard some other groups. Our whole focus is on the students.
That is not their allegation.
That is not there, but why we have done it? Earlier it was not there. There must be some reason. So, Lordship, in my humble submission, there is no arbitrariness because their allegation is that there is manifest arbitrariness on our part in amending the rules. In my humble submission, just saying arbitrariness will not become arbitrary. In paragraph 9, although it may be not supported by a numbering in the affidavit, but if Lordship wants the empirical data as well as the records, I can place it also. It is not that the officer or our counsel have written all those things. It was due deliberation had taken place. There are regular meetings, how to improve the education system. There's a huge challenge for the state government, how to improve the public education system. We are having a tough competition with the private sectors. So we are gradually improving. Our things went awry for last 20 years, but from 2011 onwards, we are rectifying whatever is to be done. So there is absolutely no arbitrariness. It is from the point of view and in the interest of the students, Lordship, we have done it so that the students get the best qualified and deserving candidates. In that view of the matter, Lordship, there is no reason to interfere with the impugned amendments of the rules. And on the other hand, Lordship, this is gone. Then 2018 will come. 2018 will come means, Lordship, what will happen? One is that we have to conduct that again because they have not challenged the provisions of that. What they got under 10A2, they want that. What is their main prayer? Their main prayer is that we have to recruit all the teachers from the leftover TET candidates who have not till now, in spite of 2 or 3 rounds of recruitment process, they could not qualify. That is the reason. That means that was the recruitment test, sort of recruitment test. Those who have qualified in 2018 or 2020, we have to depend upon them also and know better candidates, and subsequently qualified candidates will participate in the recruitment process. That is, again, in my humble submission, may not be the right way to interfere, Lordship. So in that view of the matter, Lordship, if required, after their reply also, if any clarification I have to give, I'll give, Lordship.
My lord, tomorrow Lordship will give me 1 hour time.
What about, yeah.
My lord, all these judgments, my lord, pretty Srivastava, then the other judgment, it was in a totally different context.
Yeah, tomorrow.
Tomorrow, my lord, at 3 o'clock, at second half, my lord. Yes, yes. It may not take 1 hour. It may end up in 45 minutes also.
On only one point, Lordship, I would like to give Lordship gives me that clear. What will amount to repugnancy? That point I may a little bit elaborate, Lordship. Repugnancy point. If Lordship is satisfied, I am not. Because they have strongly argued that point.
And your reply to it that there is no repugnancy.
Absolutely no.
Tomorrow.
Tomorrow.
This, this conflict.
Deeply obliged.